Okay. Go. You ready? Okay, go ahead and get ready. It's 1 o'clock. Okay. That's gonna give me one of them. What did you get, John?
I got this for you.
Go with you. Give me a piece.
Tell Larry what you called. Tell Larry what you called. He's already gone.
Got the names? That didn't take long.
I'm staying out of it.
He said.
Okay, okay.
You can
I thought you were ready. Okay.
I did.
Great. I'd like to welcome everyone here this afternoon. The purpose of this meeting is to continue the quasi-judicial item, project number 13-001-00027 regarding the Sandestin Homeowner Association SOA office building. Mr. Davis.
Thank you. I think the first item of business would be to hear from the staff, see if their staff recommendations are what they are today. And then we did not actually receive any evidence at the last meeting, so we would then go to the applicant to hear their evidence, and then to any objectors to hear their evidence. And then obviously the applicant would have a right of rebuttal. So Renee? Yeah, that would probably be a good idea. Anybody who anticipates testifying or giving statements to the board today, would you please stand and raise your right hand? Do you solemnly swear or affirm the testimony you would give to the board today would be the truth? I do. Thank you. And when you come to the podium, if you would, say your name. We have a court reporter, and give a current address, and tell us that you have been sworn, or if you have not been sworn, let us know that as well.
Mark,
Thank
I
you.
noticed a lady in the back doing this. Can everybody hear? That's what I don't think.
I'll
everybody
try
can.
not to mumble.
Okay.
For the record, Renee Bradley, Walton County Planning and Development Services. We're here today to listen to the SOA office building, project number 13-001-00027. I would like to enter some items that we've received since our last meeting into the record. The items are as follows. Tom Becknell email dated August 21st, 2013. Gulf Pine opposition letters. Setco Services title opinion letter. Email from Gary Vorbeck on conditions. Email from Jim Crew objecting to Vorbeck's condition dated August 27, 2013. Crew and Crew memorandum of law dated August 13, 2013.
Do we have all that stuff? Do we have all of that here?
You should, yes, ma'am.
I don't have the crew
I
memorandum
don't
of
think I
law.
have the crew thing.
I don't either.
I have the Setco and the warranty deeds and the
I have
Becknell
Setco,
email
yeah.
and the Gary Warbeck.
Yeah, but I don't have the
And I don't
crew.
have the,
information.
You have them all.
Is it in our packet, Renee? Or is
The
it,
one that you have in your packet is dated August 12th.
Right.
And they revised it, and I just received this one today.
they just received it today?
what is the
Yeah.
date on the Setco letter? There's no date on
There
it.
was no date that I found on it either.
Okay,
Do you know when you received it?
I
Renee?
received it yesterday,
okay,
August 27th.
okay.
Mr. Chairman, I assume those items have been accepted into evidence.
Yes, sir.
Yes, go ahead.
Sandestin's Owners Association and Emerald Coast Associates are requesting approval of a major development order for 8,807 square feet of office, 6,000 square feet of covered parking for the Sandestin Owners Association. The future land use is Coastal Center. The project's located at 181 Reeves Drive behind Footprints north of US Highway 98. Staff has received public comments from Blackshear Planning Incorporated representing the neighborhood property owners. the Reeves, owners of the Footprints retail business and home just south and east of this proposal. One concern raised by the Reeves was the safety of the visibility triangle. The engineer of record applied county and state codes and met both requirements. Additional opposition letters from the Bay Pines neighborhood has been received and forwarded to you for review. The most prominent concern from the opposition is safety at the intersection of U.S. Highway 98 and Reeves Drive. Staff has contacted Rusty Williams with DOT to see if any additional safety measures could be applied to the intersection during the review of this project. The original review required a stop bar and stop sign. Because of all the safety concerns and additional concern from the Planning Commission, staff asked the applicant to request an official safety review from DOT for the access for the US 98 Reeves Drive intersection. DOT's response to this review. Renee, thank you for including FDOT in this review process. Ideally, we would like to see a right in and right out only at this intersection location. However, with the limited amount of property available, I understand this is not possible. The other item we would like to see is a stop sign and stop bar, which have already been included in the conceptual plan. If you need additional information or if I can be of assistance, please do not hesitate to call me. Blackshear Planning also contends that this access is in violation of Chapter 380-06-19 as an additional access point to the Sandestin Vesta area and DRI. This issue was discussed with DEO prior to the pre-application meeting for this project. Being the issue was raised again during the technical review process, staff requested the applicant send the plans to DEO and request a formal review. Additionally, staff also emailed Anna Richmond for a response and clarified that she did receive the plans and the request from the applicant. Staff requested that Department of Economic Opportunity respond to whether the new access into the vested area of Sandestin created any additional impacts to the vested area of Sandestin and whether this would be considered an additional access point to the Sandestin DRI. Per email dated May 22nd from Anna Richmond with the Department of Equal Opportunity, this is her response. You have asked if the building a new Sandestin Owners Association, SOA office, in the vested portion of Sandestin DRI would impact the 1984 agreement between the DCA and the county. As proposed, the project would connect the SOA office from the vested portion to the non-vested portion via a bridge and access to Highway 98. Would be through an electronic gate with limited access, primarily for employees and emergency personnel. Given these restrictions and the proposed use, the proposed project would not create additional transportation impacts. Therefore, the project would not be in conflict with the 1984 agreement. I would recommend the county include a restriction that if in the future the project site is no longer used by the SOA, the new tenant provide the county with a transportation analysis demonstrating no additional impacts are occurring on 98, or if impacts do occur, they are properly mitigated. The vested portion of the property is being used for a bridge and primary access for ingress and egress to this project was deeded from Sandestin Investments, LLC, Tom Becknell, to the SOA on August 12th. Staff received a request from Becknell's attorney to have the property deeded back to him. Previously, Wayne Dice received this email on January the 23rd from Tom Becknell. Wayne, I was planning on attending the meeting with you, Ken, Rusty, this week to discuss the SOA's plans for their new property. Unfortunately, I will be in Washington, D.C. tomorrow and Friday. However, I did want to let you know that I am very supportive of their plans and have offered to help them in any way I can to accomplish their goals. Your cooperation with them would be appreciated by all involved. As they move forward with this process, I will be available to meet on any Sandestin questions that may come up. On August 21st, 2013, staff received an email from Tom Becknell stating the following. To all concerned parties, the email below was sent by me, which was the one I just read, to the county when the SOA had presented me with a plan for the development of the Reeves property as the Sandestin Owner's Gate. The plan and representations were to create a third access point into Sandestin to alleviate some of the congestion of the main gate. This is the same representation Ken Lloyd, Rusty Decker, and Joe Bacali, board members, made when they asked for the lake property to be quitclaimed to the SOA. Now it is apparent they have no intention of developing an owner's gate, so I am withdrawing my support for this project. Tom Becknell. Staff contacted DEO to see if the declarant's permission is required for the bridge road connection to the vested area of Sandestin. DEO did not see this as a Florida Statute 380 issue, but rather an issue between the SOA and Mr. Becknell. Additionally, staff received an updated report from Blackshear Planning that proposes multiple code violations concerning the access from US Highway 98 in the coastal center land use category. Staff does not agree that there is a violation of the coastal center land use category. However, staff does agree that the access immediately off US Highway 98 is not entirely in the access easement for the subject property. Because the existing curb cut does not match the existing easement alignment, staff recommends that the applicant coordinate with FDOT Access Management to increase the access opportunity to the west of the existing curb cut to provide full access to Highway 98 from the 20-foot wide existing access easement. Staff finds this project meets the Land Development Code provisions and the comprehensive plan policies unless other evidence is presented to the contrary, with the following conditions. Conditions to be placed on the development order is as follows. The proposed development shall only be accessed through the vested area via the proposed bridge from Audubon Drive. No improvements within the 20-foot easement shall be allowed until the dispute involving the applicant's authority to make such improvements are fully resolved. Once the easement issue is resolved, then the following conditions would also apply. If in the future the project site is no longer used by the SOA, the new tenant owner will provide the county with a transportation analysis demonstrating no additional impacts are occurring on 98, or if impacts do occur, they are properly mitigated. The SOA office will maintain an electric gate with limited access only for SOA personnel, emergency vehicles, and personnel to Highway 98. No through traffic for owners or other patrons is allowed. Number 4, the applicant shall coordinate with FDOT Access Management to increase the access opportunity west of the existing curb cut to provide full access to Highway 98 from the 20-foot wide existing access easement. Fire department conditions will also be placed on the development order. Additionally, the proposed gate shall review a full review for approval. If approved, a Knox key switch shall be installed for emergency access. Number 2, lightweight truss place cards, if applicable, shall be installed prior to the issuance of the CO in accordance with Florida Statute 5331dfdf448c, if applicable. If the applicant chooses to amend the project to remove the existing 20-foot easement from the project, the following conditions will apply. Number 1, a revised site plan that does not include the easement will be required for the development plan to include any applicable changes needed to meet the Land Development Code. Number 2, if the applicant proposes to add the easement area back to the project once the civil issues are addressed, then the project must come back to the Board of County Commissioners for approval of the additional access to US Highway 98. Number 3, lightweight truss place cards, if applicable, shall be installed prior to the issuance of the CO in accordance with Florida statutes, section 633.027, if applicable. In either case, the following permits are applicable. Number 1, provide ERP stormwater permit prior to pre-construction meeting. Number 2, provide NPDES prior to pre-construction meeting. Number 3, provide FDEP potable water and sanitary sewer permits prior to construction. I'll be glad to answer any questions for the board.
Any questions? Thank you.
Thank you.
Yeah, I said any questions. Mr. Warbeck, are you representing the applicant?
Thank you, Mr. Chairman. Board members, my name is Gary Vorbeck. I'm an attorney practice out of Destin, Florida. This is where we ended up last time. And I, at that time, turned to Mr. Davis and said staff was recommending restrictions regarding an easement and basically inserting themselves into a private civil matter between, and property rights between two neighbors. And I didn't I recommend the board, and I stated publicly I didn't think that was very good public policy and leads to all kinds of problems and possible damages and suffering loss by the SOA. So I guess I want to ask Mark if we're...
Yeah, I'm prepared to answer the question that was asked to me now, and let me start by saying to some degree I disagree with the staff's recommendation, but I want to just tell you what my recommendation is. It's my recommendation that this board have no involvement in determining the validity of either the deed from Becknell or the easement that was granted through the series of deeds from the Reeves. The deed from Becknell and the easements are on their face valid, and that's all that the planning staff and this board has to have in order to issue any kind of development order. However, there may very well be, in fact, I know there is a lawsuit now that's been filed by Mr. Becknell seeking to set aside that deed. That's for the courts to decide. You just today have a deed in front of you that we would have to presume is valid, okay? Now, I've been told that that has not been the position of the board in the past, and I've been cited to the Driftwood restaurant and Benazzi applicant to build that Driftwood restaurant. And in that case, there was a deed that had on its face a reverter clause. In other words, the deed had in front of it, sitting in the middle of it, a reverter clause that said if that property is not used for residential purposes, it would revert back to the original grantor. So on the face of that deed, there was a problem that needed to be resolved before a development order could be issued. That's a different situation than when you have a quitclaim deed and an easement which on their face are valid. Ms. Crew may very well be right and win that lawsuit, and that's a risk that the applicant will have to take, because if you go to the extremes, and that's what we have to think about as lawyers, if we grant this development order with or without those conditions, okay, we say nothing about whether or not the access or the deed is valid, which is what I'm recommending. If you do that, and Mr. Vorbeck's client elects to go ahead and proceed and build the building, and then Ms. Crew and Mr. Becknell win their lawsuits, he's got a building he either has to take down or he can't use. Okay, so it puts, frankly, the applicant at risk, and it keeps the county from being at risk. And here's the risk the county faces. If we indeed granted the development order and put the conditions on there, and Mr. Vorbeck wins the civil lawsuits, in my opinion, it would place us at risk for the possibility of delay damages. In other words, whatever damages that the SOA has as a result of that delay. Because we conditioned the development order upon that being occurring, we could be possibly at risk for damages for that. And that's just not a risk I think you should even undertake or even think about undertaking, frankly. In my opinion, you would be better served, and it's my advice, to consider the development application only on the questions of whether or not it complies with the Land Development Code and the comprehensive plan. Similar to something we had yesterday, frankly. I think that's where we are in this case, or this particular matter. Mr. Vorbeck still has the burden of proof to prove that the development order request does meet the Land Development Code and the comprehensive plan, but those other issues, and we'll take testimony on those other issues, frankly, because I don't want to preclude them from bringing them up and creating a record if they choose to do that. But it is my opinion you should not pass on the validity of either the deed or the easement. Okay. Does that answer your question?
Yes, it does.
So we cannot condition approval or disapproval on anything having to do with the easement?
The validity of the
deed.
easement or the validity of the deed. Yes, ma'am.
Okay.
But aside from the validity, can there, if we chose, because I want to understand what you're talking about, to say only emergency vehicles or their SOA personnel?
If I can interrupt, Commissioner Commander, we stipulated to that in front of the thing we stipulated that the planning board recommended we stipulated to is we limit it to employees.
Okay.
And
emergency vehicles?
Emergency personnel.
Okay.
And we but it'd be, the thought was emergency situations, but yes.
Because I thought at our last, of course, it was, close to midnight. I thought you had taken that off the table, so I wasn't sure. Okay.
Well, we did stipulate to that, and that was stipulated in the effect that there wouldn't be any other conditions. We did that just, and it's a very good point, we did that because we've been trying to work with the neighbors and trying to satisfy everybody we can. And one of the things which was, if you all, the planning board says you all stipulate and you all make it part of the record that as a condition you limit it to employees, then yeah, we did that. But we thought that was going to solve everything. But then it seems like every time we give something, there's more and more, you know how that works, more and more issues that the opposition comes up with. But that was one of the major issues, the limit to employees, limit to emergency vehicles, and it would make a lot of people happy. Well, it didn't make a whole lot of people happy, but we did it.
Okay.
And
So it was from your point of view. I don't mean to interrupt, but from your point of view, is that was like, okay, if there's not any other conditions, we'll agree to that.
Okay, so today you are agreeing to that?
Yes, if that, yes.
And Commissioners, one last thing. That does not mean you cannot consider whether or not the easement as given, or the deed as given, is adequate in terms of size and all those other issues that have been raised. But as to the validity, I don't believe you should pass on that.
Okay.
Thank you.
What I'm going to do is I'm going to introduce Dean. Dean's going to go through all, Dean Burgess. Dean is going to go through all the issues that he has, or all the details he has with the development, and you're free to ask any questions. Also, here is Mr. Ken Lloyd, who's the president of the SOA. And I've already given you all in the background, you all, from my talk last time, that the SOA does represent 4,000 residential homes and over 1 million square feet of commercial, and well over $1 billion in tax value. And they're using this as an office space. They're cramped. They're in private. They have to rent it. Of course, the prices they have to pay for rent is outrageous, and so they need another space. They have approximately 18 people working in the office, and their intent is just to use it for those folks. And they do have, now as has been talked about, and Dean will go through this, but they, just generally speaking, they've required property on the north end of the property, and Dean will go through this in detail again, but that they can try to use for access. But the important thing, and it's really important, one of the real objections we have with staff's recommendation that's been discussed, is that they want to say that we can't use an easement, that partial consideration of $1.2 million was paid to use the property for construction. In other words, the staff has been taking a position to me that easement couldn't even be used for construction, which would make the project nearly impossible to do, because as Dean will explain, there's lakes on the north end, there's ponds in the north end. It's very, very important that easement be used for construction. Now, of course, the neighbors, if they don't think that's correct, if they don't like that, if they think that's against some of the violations of their rights, they can bring in. They have a remedy, and they could bring an injunction against the SOA to challenge that. And of course, the SOA feels confident in meeting that, but that's what's so important. You'll hear that over and over again, that we need that right of way for construction, and that's what was dedicated to our deed to us.
Could I ask you one question, Mr. Boyer? When you say for construction, you mean bringing in the construction material to build the building? Is that what you're saying? Yeah,
yes,
I wanted to make
not for operations. And we were hoping staff would limit their recommendation, their condition to say, because what you all are approving of building and operations, and the staff came out and said, basically, and I'm not quoting them, but basically says, we're going to limit your access to the north, from the north for the building. And that should go to operations, because that's what you're permitting, a building and operations. And I've never heard of a county or a local government get involved in access, how something is constructed. And that's our biggest concern. We need deep assurance that those are property rights that we have, that we need to construct that building. As everybody knows, it's very, very important. So it basically render the property useless to us if we can't construct the building.
You couldn't bring in construction material any other way?
No, because we're going out, we're going to have to build bridges, and Dean will explain this, over a couple of ponds to get out. Okay? So what I'm going to do is I'm going to have Dean come up here, and I know you want to get to the meat of this thing, and Dean will explain the project. Also, Ken Lloyd's here to answer any questions that you may have. And then if you allow testimony as to the easement, we have title experts too that we want to bring up and use as rebuttal. And if that's not allowed and the board doesn't decide to hear those easement issues, then we might not even need to bring those. But we got to match evidence for evidence if we need to. So if we could, and the title expert is named Mr. George Brain. So if I would like to introduce Dean and let him testify.
Mr. Warbeck, hold on, please. Mr. Mark, if this easement issue between the two parties is something we don't need to get involved in, do you see the need to have all this easement discussion going back and forth when it should be in a court of law?
Mr. Chapman, here's my answer to that. Yes, we probably need to go ahead and let both the objectors and the applicants build whatever record they feel, because the objectors are not going to agree that it's not for something for you to decide. So it's my opinion that to grant them fundamental due process, that they should at least have the opportunity to present their evidence. Again, I don't think you should pass on it, but they should at least have the opportunity to present their evidence. That way they have a record if they decide
Very
to
well.
appeal this decision.
That's where Mark and I disagree, and I'll object to it. I don't think it's relevant, but I understand where Mark's coming from.
I must be right, because they're both going to disagree with you.
So at this time, if Dean Burgess would come up. Just real quick. Oh, by the way, Dean's going to testify, and then the president, if you need to ask any questions, and then I'm going to summarize it. But at the end of the summary, and there's not a good point to do this, as you all know, is I want to make sure the record's correct, and because we've had kind of start and stop, I'm not, and some of the copies I got from the county attorney. So after I'm completed, I'd like the right to make sure that our record's correct and we get the appropriate documents in the record as possible. So it's a little bit dry, but we'll have to do that. And I'll do that right at the end of our case, in chief, if that's okay.
That's perfect.
Okay. Now, first of all, I'd like to introduce Dean Burgess, and just a little formality. Dean has his CV to introduce into the record, if you would. We need one.
This young lady doesn't know who we are, so make sure everybody knows to tell her.
Oh, well, thank you. Commander has correctly pointed out to me that we have a court reporter here, so it would be real helpful if, before you start talking, you'll say your name so she'll know who's speaking.
And do we need, as you practice, to mark these documents as we go, or how we run?
We'll mark them after we get along. Yes.
Okay.
Good afternoon, Commissioners. My name is Dean Burgess, 179 County Road 393. I'm with Emerald Coast Associates. I'm the agent to the SOA on this particular project, and engineer of record. To start with, just a brief description on the project that's before you today. The SOA office building is on 2.61 acres, combined with what we call a lake parcel. Shown on this exhibit, and it should be in your packets as well. That parcel is utilized to cross the lake and access Audubon Drive to the north. That gives a total of 3.72 acres for the development area of the project. Land use category, as Renee had mentioned, is coastal center. We're proposing 8,807 square feet of total floor area, making our floor area ratio 13%. There's an allowable floor area ratio in coastal center of 85%. So we're utilizing 15% of our available intensity for floor area ratio. The impervious area on our site plan is 66,649 square feet. That equates to an impervious surface area ratio of 42%. Allowable impervious surface area ratio in coastal center is 85%. So we are at 49% of our intensity of impervious area for the project. Required parking for the project is 36 spaces. We provide 51 parking spaces. So we have 42% excess parking than what the code requires in our project. Coastal center is a land use category that, by definition of policy L-1.3.6 of the comprehensive plan, is intended to be primarily residential with supporting commercial uses. The use of the building is for an office building for the SOA. The primary use is obviously in the area is the Sandestin Resort. We have the outlets and the shopping, Sandestin shopping mall to the south, and of course the resort is to the north, and this property sits immediately adjacent to the resort. So I think it's clear that the primary land usage in the area is residential, and this is a complementary and supporting commercial use. You may even acknowledge that because the SOA office building is not for profit, it really functions as a civic use to Sandestin. which is also an itemized use that's allowed within Coastal Center. Commonly within Coastal Center, there's discussion about outdoor storage of equipment and materials. The SOA has duly taken note of this. Any equipment that they have off-site facilities that will remain for equipment storage and to place their equipment and materials. No equipment and no materials will be stored on this site. That was clearly presented to the Planning Commission, and I wanted to make sure that's presented to this board as well. Based on the discussion of the staff report and the conditions brought up by Mr. Davis, we concur with staff's recommendations. We would like to ask that this board not evaluate the easement as part of the approval of this project. Mr. Vorbeck had mentioned about the bridge as far as construction of the facility. The bridge is necessary. The construction of the bridge requires the use of the access for construction. It's simply not feasible to construct the bridge entirely from the north side. It would need to be accessed from both sides for staging of equipment and construction of the actual bridge. Based on my design and review of the project, I concur with staff's report that it meets the Land Development Code and Comprehensive Plan. I'd be happy to entertain any questions that the board may have.
Any questions?
Yeah, I just have a few technical questions. Dean, is there an exhibit that shows that Renee mentioned that the easement does not follow, that the paved area, I guess, doesn't follow the easement?
Yes, and I wanted to.
Varies from that. Do you have an exhibit that shows where that is?
It is shown on this exhibit.
Or how that?
I'm happy to bring it before you.
Yeah.
That is one of the conditions that we agree to stipulate to. What our attempt was to utilize the curb cut that's there in its current configuration and not go through DOT for a adjustment of that. Understanding that the concern that's been raised, basically what the problem is the western roughly 10 to 12 feet of that easement does not line up with the existing curb cut.
Okay, you gotta bring it so we can, you know.
So you can see that our proposed road is shown in gray here, our access. The easement, this sliver here in white, is what is misaligned with our easement.
Oh, okay.
Understanding that we're gonna have to stay in our easement, that's a concern for the neighbors, we will go ahead and move or extend, whichever DOT prefers, this curb cut to line up with our easement. So we can come and go through our easement and not have to veer on outside of the easement.
Okay.
So what we were doing was
Yeah.
the easement extends only to here, and you can see this narrows down to a width that is not 2 lanes.
Yeah.
In order to maintain a full 2-lane access, we would have to move this easement to the west.
Okay, and that was my second question is, when you say provide full access, you're talking about once again, 24-foot paved, what is a
It would be
full
20
access?
feet, 20 feet wide.
20-foot wide paved?
Yes, ma'am.
Okay. So
Dean,
that's what you mean by full access? Okay. That's okay.
Dean, you mind pulling that back up, please?
And I have a question with it too, Dean, so just, you'll keep it, yeah.
Where is the electrical power easement in relationship to that cut and the southern boundary line of your property in question?
There's an electrical easement within this 20-foot access easement. There's also an electrical easement in there.
And the business that's there now, Ms. Reed's business, that's the square building, right there?
This building here is the Footprints building.
Footprints, and she uses, where your finger is right then, she uses that for her parking?
She uses this for access and parking for her building.
Okay.
Yes, ma'am.
So,
Yeah, and the question is, how is that gonna impact her parking
yeah.
there? How's that gonna impact it? Are cars gonna back out into the, because right now, they pull in and they have to back out.
Yeah.
Right. The turning movements into footprints would remain exactly as they are now. They would use the easement, and they would pull into those parking spaces, they would back out of those parking spaces, and travel south on the easement. So their turning movements would be identical to what they are now.
Okay.
There'd just be a little bit more traffic there to watch out for. Is that
Right,
what you're
well,
saying?
when we extend this easement, there would actually be another roughly 12 feet available here for them to utilize, because we would be paving that as well.
Okay.
So the access would actually be increased.
Real quick, if I could,
Go ahead.
that this could actually be, as you stated, will be as it is today, the impacts from the residential portion of the property, the multifamily portion of the property, is actually, this would be a lesser impact.
Based on our traffic analysis, that's true. The existing trip generation on the site and its current use created, I would have to consult the report, I believe it was 8 trips, and based on our traffic analysis, with the ability to utilize the connection to Audubon, would reduce it to 7 trips.
Now, does the business have any other accesses, this commercial business, non-property, existing commercial business, do they have any other access to the property?
The footprints does have an access here to the east of their building on this side as well.
Okay.
Thank you, Dean.
Okay.
Appreciate it.
Dean, you said there was access to footprints on the east side. Is there parking there?
They have access and parking both on the east and west of their building, so on either side of their building, yes, sir.
Thank you.
Any other questions for Dean? You through, Dean?
I am.
Okay, thank you. Mr. Vorbeck?
Dean will be, well, you probably see Dean again on any rebuttal that we may have. So I want to definitely reserve that right to bring Dean back for that. Now, I just want to make available to you the president of the SOA, Mr. Ken Lloyd, if there's any details you want him to discuss as far as how they'll operate, anything else, he'd be more than happy to answer them for him to the best of his ability. So if you have any questions, anything that's been stated that you want to know about the SOA as far as how they see it to be operate or how they want to.
Are there any questions?
No, I'm good.
Okay. Now,
Okay.
just for the record, in reviewing this and representing the SOA, they have done a really good job trying to work with everybody, and they've been they were very cautious when they bought the property. They put an option on it first, and then they checked with the county, to see what could be done, and they went through this with a fine-tooth comb, only to result in the stumbling blocks, like it often happens with neighbors and such. But they've tried to meet with the neighbors, and they have met with them, and they have not worked out and been successful working out any compromises. But they have worked diligently with staff. They've, as the staff stated and testified, they complied with the comprehensive plan and land development code. As Dean's testified, Mr. Burgess testified that they complied with the comprehensive plan and land development code. And as the county attorney stated, that is what you need to judge the application on. And we agree with the staff report, except for the condition of limiting, trying to invade our rights for the easement, try to take our easement rights away or delay them, as described by Mr. Davis. Other than that, we agree totally with the staff report. And again, what the staff report would do is literally prohibit us from constructing the project if we're not allowed to use the south easement, the deeded easement. Now, again, I really want to reiterate, the neighbors, the Reeves, if they want to challenge and bring an injunctive action against the SOA, they are more than able to do that, and they can challenge the quality of the easement any time that they see fit. All we're asking, as the county attorney says, not to interfere with our property rights regarding that easement. Now, what I'd like to do is, I guess, at the conclusion here, so we're asking you to approve this project. The SOA has been amenable to reasonable conditions on here and will continue to be. But we think this project is obviously in compliance with the comprehensive plan, land development code, and we think it's a definite necessity. It meets, as Dean stated and staff stated, it meets the intent and language of the comp plan classification. And I really think there is no other alternative but to approve this project. And what one of the things too I want to bring to your attention is this would be if they're kind of being treated. I feel like they're being treated differently than any other user of Highway 98 in that the property, if they didn't have a northern access or availability to go to the north, as Dean described, that this property has an access, like many other properties do, an easement to Highway 98. The only reason that we're getting run through the ringer here is because there is another available access. And if there was no other available access but the southern deeded access as any other property, if somebody else would have bought this particular piece of property, then there wouldn't be any issues. And so the SOA feels somewhat put upon that more is being demanded out of them than they would anyone else. So they again want to continue to be good neighbors, and so we're asking you to approve this project. We'd like to reserve the right to rebut, but also at this time is when I ask I could make sure we have the record correct. So if you take it, I can have a couple minutes of the board's time to make sure the record's correct. Okay, the staff report is part of the record. So, yes, the staff's report is part of the record, and all the attachments there too. Correct? The SETCO letter, I understand that was just introduced. We have it available.
It was introduced with Renee's staff report.
And that's part of the record also, yes, SETCO letter?
Yes, sir.
Okay. Site plan is part of the record. The Kimley Horn report. And why I'm doing this, because we got kind of discombobulated last hearing. I just want to make sure these are correct. Kimley Horn report part of the record? Okay. We'll put the, if we could, at this time. This is, you all have copies of this, I'm sure. This is the report, was part of the introduction, part of the application. But we just want to make sure that's part of the record.
Just for clarification, Renee, was it part of the first staff report? It was part of the original submittal, so it is part of the original record. Oh, it's not? Okay. Okay.
Renee read into the record, so that's part of the record, the emails from EDEO and DOT.
This is the
No,
Kimley
ma'am,
Horn is part.
No, she was talking about the DEO.
Oh, okay.
Yes.
The warranty deed was part of it too, Renee?
We entered that at the last meeting, the warranty deed.
Yes, that's correct.
Warranty deed's part of it. And the title policy, I know I entered that. That's part of the record?
Yes, sir. It was entered at the last hearing.
Okay. And that's fine. One other thing that I would like to point out, and I appreciate the board's patience in making sure we have a complete record, is our opponents, our neighbors, have done many things to oppose this project. And they have lobbied DEO, they've lobbied DOT, they've lobbied staff, and none of that to any avail. And the record shows correctly they've lobbied several of y'all. I don't know if they've lobbied every one of you, but they have. Record shows that some of the folks have been lobbied. Some of the board members have been lobbied. Everyone that's looked at this, whether it be DEO, DOT, the staff, has listened to them and kind of disregarded their arguments and their positions. They've done an email campaign against this to get letters sent to in opposition, and if you notice, most of them form letters. And then they've also done something that I'm not going to make part of the record, but this is a new experience for me in all my years been doing this, is they went and took out an advertisement trying to stir up some acrimony and make it more acrimonious, and I'm sure you're all aware of that. And I just want to just state that it seems like they're just trying to do everything they can to throw something against the wall to kill this project. And the SOA has done everything it can to meet the Comprehensive Plan Land Development Code, and has done so. So again, we're just asking that you disregard this and please approve this project as recommended by the Planning Commission with the conditions the staff has, except for that one condition regarding the status of the easement.
Just a comment on that. And we talked about this, I think, yesterday at a hearing. People have the right to express their opinions. They can take out an ad in the Wall Street Journal if they want. They can lobby whoever they want. Y'all lobby as well. So we all have a stake in this, and so I think, bringing that up is kind of disingenuous, because, everyone has a stake in it, and everyone has an opinion, and they have a right to that. So I kind of take exception with you bringing that up, but that's neither here nor there. I do have one more question for Dean. Yeah. Dean, if you moved the easement to the west as proposed, would you be able to accommodate DOT's request for a right turn in, right turn out only?
We wouldn't be moving the easement to the west. We would be moving the existing pavement over to the west.
Right. So
we still only have the rights to 20 feet there.
Okay.
And within 20 feet, yeah, we can't.
That doesn't give you enough room to do a right. Why doesn't that give? I guess my question is, why isn't that enough to do a right in, right out?
By DOT design, a right in, right out has a lane in, a lane out with a triangular area between the two, separating them. It's that triangular area that we don't have enough space with. We have enough space for the two lanes, but not the little triangular area. Now, one thing that we have discussed with the board, and they're not opposed to, is putting up signage. It's not a DOT compliant as far as geometry, but we're not opposed to putting up, right turn only or no left turn sign out of the driveway.
Okay.
All right.
And who would take that, I'll call it the curb, will you have to request for DOT to come cut that curb?
They would probably have us do the actual construction as part of our project, but we would have to permit it through them.
Permit through them.
Right.
Okay.
Thank you.
Commissioner Meadows, board members, I just talked to the president, and I believe they look favorably on limiting that to the right turn.
Right turn out.
Yeah.
Yeah.
Okay. Thanks.
Excuse me.
Ms. Crew will be next. Ms. Crew?
I'm assuming that's the end of your
I'm assuming,
presentation.
you through, Mr. Borbeck?
He's never through.
No, I'm never through, but I apologize and thank you for your patience. And again, we would very much appreciate approval of this project.
And I believe that would be the objective.
Yes.
Would be next.
Ms. Crew? Are you ready?
I am.
Okay.
I have.
Okay, go ahead.
raised any?
So,
Dean, is there any way it can be raised any, or is that as high as it goes?
Is there a ledge there?
Not really, you kind of have to hold them up there.
Yeah,
if you-
unfortunately, yeah.
Well, when I refer to them, how about I hold them up and I'll
That's
bring them
good.
close?
Okay.
That'd be fine.
That'll work.
That'd be
For those
fine.
of us who are blind.
My name is
You're blind.
Jill Crew. I'm a lawyer with the law firm of Crew and Crew. I represent the Reeves, and I'd like to introduce them. Mr. Doyle Reeves, would you stand up? And Mrs. Janet Reeves. The significance of the Reeves in this case is that they actually own the fee interest of the property that's the subject of this development order application. They're not a remote neighbor. They own the fee title. Keep in mind that what Sandestin is talking about is an easement. Easement is not a property right, it's a privilege. So that is the fundamental issue I want you to keep in mind for today. You'll also be hearing from our expert witness, Ms. Pat Blackshear, and Mr. James Sullivan from the Genesis Group, who was previously with FDOT, who is a traffic engineer. Now, these two experts of mine have already been admitted as experts in a prior Planning Commission meeting, and if we can have a stipulation from Mr. Davis that they were in fact acknowledged as experts.
That's true, they have both been qualified in prior hearings.
Yes, and that's fine.
Before you is an interesting development order application. Why is that? You've got two property owners that are involved that object to this project. You have got the Reeves, the property owners of this property here. Mr. Becknell, the developer, successor developer of the Sandestin DRI, objects to this.
Mr. Chairman, I don't mean to interrupt, I just want to preserve my objection. I understand how the county attorney said, and so I just want to, on the record, one time object to any testimony that is not relevant with regards to these.
Yes, sir, and since we're not actually in a courtroom, that objection can be made continuing, so you don't have to do it every time.
All right, but
But we're going to, yes. Yeah,
Very
right,
good.
yeah, we do.
so two significant property owners whose rights are directly affected oppose this project. I have previously distributed a written memorandum of facts and law, and I believe it was entered into the record, but just for clarity's sake, I want to ensure that the memo that was handed out to you is admitted into the record, as well as Ms. Pat Blackshear's technical expert reports, which she will speak to, and Mr. James Sullivan's report. The engineer has an expert written report you should have before you.
Jill, just to make sure we're clear, you want all three of those items entered into the evidence today?
Yes.
Mr. Chairman, I assume that's okay with you? Okay, there.
Fine.
All right. Let me give you a bit of history about the Reeves property so that you understand their objections. The Reeves family has historically owned this entire 6+ acre parcel. It's been used for residential purposes except for the footprints business right along Highway 98. Now, significant, and this is a survey that was submitted by the applicant. So I'm actually referring to a document in their application. You will notice that in their application, they have 11.01 wide driveway, 11-foot wide driveway at this point. Why is that? There is a Gulf power easement and a power pole that is on the western side of the driveway. As you discussed earlier, the Reeves parking lot is on the eastern side. So this applicant proposes to significantly modify a driveway and to have an entrance and an egress of 11 feet because it is physically limited because of the power pole and because of my client's parking lot. My clients have historically used their property, except for their footprints, for residential purposes. The diagram here shows the historical and the to-date driveway. And the driveway is an 11-foot wide meandering driveway, and you can see that in your Exhibit A. And this is how it has always existed. And in particular, I want to point out to you, this is the condition when Sandestin Owners Association purchased it, is the driveway never connected to the property on the western boundary. It meandered up and connected at the southeastern boundary. Why is that? Because of residential. This driveway has always and only been used for residential access to the residential homes on this parcel that Sandestin has purchased. Now, you'll notice that the meandering driveway, which you can see in Exhibit A, bears no relation to the 20-foot wide easement they could make claim to. And again, the fact that there's a power pole in their 20-foot easement gave them additional notice that it may be an access problem. And there is, in fact, an access problem. The Reeves don't object to someone buying the parcel and using it for residential purposes, as it has historically been. And the Reeves certainly wouldn't object to residential owners accessing their meandering driveway in its existing condition. But when Sandestin purchased this lot, seeing the driveway, the limitations, and other factors, they did so with the idea that they're going to change the entire nature and scope of this parcel from light-use residential to a 9,000 square foot building with a minimum of 65 employees. And there may be more. From what I hear, there are security guards and various other people that may not fit the true category of a full-time employee. Sandestin now anticipates using my client's property for a minimum of 65 plus people for commercial purposes. That is what my clients object to. My clients live on this on their parcel here. Their children live here. They have grandchildren that live on their parcel. So you understand, there are homes here and here for my clients with their children and grandchildren on the premises. And all around this parcel that Sandestin purchased is residential. Of course, this is a lake, but residential. So Sandestin purchased an interior lot that it knew had been used for residential, that all the parcels around it were used for residential, and decided to change the scope and nature to high-density commercial. That's what my clients object to, them flowing the traffic onto my client's property. Now, one thing that the applicant has failed to show in their application is that their property, as well as my client's property, is subject to a recorded grant of easement from my client's parents to Gulf Power. That is a 10-foot wide easement along the western boundary of my client's property, as well as along the western boundary of Sandestin's property. The significance of that easement runs power to along the western line, and then there's a power line that crosses over Sandestin's property to residential homes that my client's children live in. Now, this parcel that Sandestin purchased is a unique parcel that was carved out of a 6-acre plot. And it was carved out by my client's parents. And it was carved out for the purpose of granting 4 acres to my clients, Janet and Doyle, for their home. And their parents reserved the 2+ acres for themselves, for their home, and for their son. And yes, there is a quitclaim deed to their other son, who did reside on the premises until November 2012 when he sold the property to Sandestin. And my client's parents lived on the property, and so this has historically been used for residential purposes. For the technical and legal grounds that I'm going to cover as to why Sandestin's application for a development order must be rejected is multifaceted. The first aspect is that, what I mentioned, there's a 10 to 11-foot wide driveway. Now, how did that occur? How could someone have had residential development in these 2 parcels and yet be allowed to have 11-foot wide driveway, 1 lane, to access those parcels? Well, the answer is in 92, FDOT took a significant portion of my client's property and left them with 11-foot wide driveway. Now, did that cause a code non-compliance? Yes. Is it grandfather? Absolutely. It's a grandfather non-compliance for residential purposes only. Now, Sandestin is proposing to put a commercial facility, 9,000 square foot building. This is no longer a same use. Now we have a change of use of this parcel. And what's the significance of that? Well, your ordinance says when there's a change in use for a major development order application, the project has to be brought up to code. So the driveway, in order to be brought up to code, our experts will testify, needs to be a minimum of 24 feet wide. And that's impossible because of the geographical constraints. A power pole on one side, my client's parking on the other. And I'll just refer you to your ordinance for the definition of a change of use, which triggers the application of the code and disqualifies someone from having a grandfathered noncompliance. Change of use is defined, among other things, as a change of land use from residential to commercial. So if we've established that there is a change of use and we have a non-code compliant driveway.
Jill, just for reference, can you give us the code provision you're quoting from?
If you look to the definitions section of the Land Development Code, actually in the defined terms, the term change of use is defined. And I actually have that in my memo. A change of use is constituted when there is a change from one classification to another, commercial to industrial, retail to entertainment, residential to commercial. So for the applicant to suggest that this project is code compliant is not accurate. It simply is not code compliant with respect to the driveway itself. Now, an interesting situation has come up in my practice in Walton County. I've actually dealt with several other applicants who have come to the county, who have come to the Board of County Commissioners with similar type of projects, maybe some projects that are less of a change in use. And the county has consistently said, and I'm going to refer you to written confirmation by the county, that if a project seeks a new development order, and if in that situation, all aspects of the development have to be brought up to code, and if the driveway in particular on a couple of these issues that I've worked on is not able to be brought up to code, then the county will not issue the development order. Now let me take that one step further to an issue that Mark Davis is well familiar with. Mr. Carl Fireman had a grandfathered commercial use. He had a grandfathered driveway access on someone's property. It was an easement. Similar situation to the Reeves. In fact, almost identical, except to the extent that Carl Fireman was only seeking to change the future land use category so it's consistent with the historical commercial use. And I'm going to refer you to the county's position. The county's position is where someone is a landowner and there's an easement driveway on their property, they must consent to allowing the driveway to be improved. And if that easement landholder doesn't consent, then the development order will not be issued. And I refer you to Exhibit C. Exhibit C is communications between myself and county staff, and also involve Lynn Hochier, who is now with the special land use attorneys that you're using. First of all, Mr. Carl Fireman had a partially asphalted driveway and the rest dirt graded. The county said he had to bring that up to code. Well, in order to make changes to that driveway, he had to get the consent of Mr. Davis's client, Ms. Atkinson. I had many conversations with Mr. Davis saying, we need your client just to allow us to asphalt the rest so we can get our development order. Well, guess what? They frustrated our attempts to get a development order because they said they were not going to allow us to make the changes necessary. And so what was the county's final position, and I believe it came to this county board, is that, as stated by the county attorney, Lynn Hochier, this is a civil matter between two property owners. The county cannot grant this applicant permission to improve someone else's property. This has been the Walton County Commission and staff's position historically. There are a host of other examples. Now, I have to wonder why it is that in the situation involving Mr. Davis's client, it was okay to frustrate my client from getting a development order by not allowing them permission to improve the easement. But yet, in this situation, we've got the same thing. We've got an applicant who doesn't own the property. They have a privilege. They claim to have an easement. They want to improve my client's property. They want to improve it to a 2-lane. They want to put utilities under their property. They want to grade it, raise it, asphalt it. My clients say no. So I ask you, how is it that in the Carl Fireman matter, that the county will not grant permission to an applicant to approve someone else's property, how is it that Mr. Davis can recommend that you approve this application knowing that my client doesn't approve the changes to their property? So I ask, at a fundamental level, consistency in the way the Walton County handles its applicants. Now, I realize Carl Fireman is an individual, and he's a little different. But Sandestin Owners Association is a very large, very powerful, wealthy group of people. So is there disparate treatment between those maybe that don't have and those that have? I'm asking you to consider that in this situation, you're being asked to go against the county policy, against written policy from your attorney at the time, and this is the policy that Mr. Greg Stewart is telling you to respect. There is a dispute. Let us resolve it before you grant approval to allow them to come in and asphalt two-lane my client's property, because that's what they will do. Now, there's another interesting aspect about your land development code, and it's it's an interesting language here, and let me read to you what constitutes a complete application from an applicant for a development order. Your land development code at chapter 11.0201 says, for all major and minor development orders that must undergo development review, and I'll skip to the relevant part, a completed application shall be signed by all owners of the property subject to the proposal. All owners of the property subject to the proposal. So let's go back to my clients. Are they subject to the proposal? Absolutely. Are they a fee owner? No dispute about that. Have my clients consented to the application? No. Have they signed for the application? No. And in fact, we're here to say we object, because under your own ordinance, you require a property owner such as my clients to approve. And this is consistent with how you treated the Carl Fireman matter. You required the underlying property owner, the individual who held the property where the easement rested, to approve. Otherwise, you would not grant the development order. Now, a minor point, and I mentioned that the applicant failed to disclose the existence of this Gulf Power easement and the power poles that run through it. Now, another interesting thing, we've heard the applicant talk about all the changes they want to make to the easement, driveway, to the curb cuts. My clients don't approve of these proposed changes. And I'll direct you to a document that the applicant has submitted to the county, which I don't believe has been submitted to FDOT, and that is Exhibit D, driveway connection. In order to make the changes they want, they need to submit a driveway connection application to FDOT.
Hang on, she had to fix something. There you go, Matt.
Page 1, landowner. Same as applicant, they say. They say the landowner is Sandestin. Well, we know that's not true. The landowner is not Sandestin. Sandestin claims to have an easement of privilege. My clients own the fee. My clients have not consented to this, nor will they consent to any changes to the driveway. an interest.
You ready? You ready? Okay, go ahead. I think you just unplug it and plug it in. Okay. Go ahead, Ms. Crew.
Thank you. All right. I know you've heard Mr. Davis discuss the easement. Is there an easement? Is there not an easement? Well, Mr. Vorbeck referenced George Brannon as being their expert. George Brannon is with Setco Title. Setco Title is the company that closed Sandestin's purchase of the property. Setco Title issued the title policy. What's interesting about the title policy is it makes reference to my client's property, the deed that they received from their parents. Well, and I realize this is getting into a legal analysis, but I have provided you with what is deemed to be a sufficient grant or reservation of an easement. I have done that in Exhibit E. Now, this is something that Setco Title, since they referenced my client's deed, certainly has knowledge about. Right, let's talk about when my client's parents deeded the property to them. The applicant says that there's an easement that was given. So in order to create an easement by someone who is a grantor, there's specific language. Let's look at that language. Exhibit E, Flodger, which Mr. Davis will be able to say is one of the most recognized treatises in Florida. This is their recommended language. Grantor reserves to himself, herself. In this case, it would have been my client's parents. And to their successors. What does that mean? That means it's transferable. It can go from one owner to the next. To their successors, heirs or assigns as an appurtenance to their land. That means as a privilege to their land, which is specifically described below. The right to use the passage in existence. What I'm asking you to do is look at what it takes to create an easement. If you turn to the next page, Amjur is a nationally recognized legal treatise. Once again, there's specific language of what creates a binding, transferable, perpetual easement. Again, the grantor reserves to themselves, their heirs and successors, transferable, perpetual, the right to do something, in this case, have access across a particular parcel and in favor of the grantor's parcel. Now, I'm going to ask you to go to Exhibit F. This is my client's deed. This is the deed that my clients acquired, this parcel. And remember, their parents retained this parcel. So, if there is a valid binding easement, a reservation, I ask you to point it out to me in this warranty deed. Let's look at the first page. Does anyone see any type of reservation language that I pointed to you that is acknowledged by Flodger and Amjur as being the standard type to create an easement?
I'm sorry, which exhibit are you?
Exhibit F.
Okay, gotcha. And
I will
repeat your question again, I'm sorry.
Well, I'll cut to the chase.
Okay.
There is no reservation language at all in this deed. There's nothing that says the grantor, J.C. Reeves and Louise Reeves, hereby reserves an easement to themselves, their successors, their heirs, transferable, perpetual, across my client's property and for the perpetual benefit of their property that they retained. There is no reservation easement language in their deed.
Just so I'm clear for the record, I just want to make sure I'm clear. Your argument then is that the language in the property description saying the above described parcel being subject to a 20-foot easement is not valid or not sufficient to create an easement. Is that your legal argument?
That is accurate. Subject to does not create an easement. The language that I pointed to you, amjure, flodger, is the necessary language to create an easement that's transferable, perpetual, binding. Subject to language, Florida courts have acknowledged, doesn't create an easement. So what does that mean? Subject to. Well, that means you go through the property records and you see what easements are of record that triggers the subject to. There is only one easement of record. That's the Gulf Power 10-foot wide easement. That's it. You can look at Setco's title policy and you'll see that there are no other easements of record that would have been created by the grantor. So, was there a Scrivener's error? I don't know. Quite possibly. But why would the subject to language talking about a 20-foot wide easement be so different in form from what the actual driveway access was? There's something wrong here. It's possible that that subject to meant the Gulf Power easement, but at some point, Sandestin, with all their resources, had to realize that there's an inconsistency. There's something wrong. There's a driveway that provides access to the residences that is very obvious, that has been there forever. And there is no 20-foot wide easement along the western side. In fact, there's a power pole. So at some point, Sandestin and its title company should have realized there's a problem here. And I don't believe it's your role to fix it to the benefit of Sandestin and to the detriment of my client. This application is very interesting in another respect. You heard Mr. Vorbeck describe the title policy that Sandestin got. Well, that title policy is significant because that title policy makes reference to an order, to a court decision that occurred in this jurisdiction, Circuit Court of the First Judicial Circuit, signed by Louis Lindsay, the judge. I don't know if any of you recall him. This case involved the Reeves trying to enforce an easement, but this is a recorded easement of record, across Hidden Dunes property to the beach. Now, this order is referenced in the title policy, and why is it so significant? It's the language in this order that is controlling and properly reflects Florida law. The court said to the Reeves, we acknowledge that there is a recorded easement, a grant of an easement from Hidden Dunes. That was the first step. There is a recorded easement. The second step is, to what extent could the Reeves use this easement? because when this easement was first granted, Footprints didn't exist. But now Footprints is a viable business. So the question is, once there was a change in use of my client's property, some commercial use, could that commercial use that easement? And the court said no, absolutely not. And here's the reason. You look to the date in which an easement, a formal easement, reminding you, is granted. In the situation with my clients, their parents deeded them the property in 1997. 1997 is the operative year. What was the driveway being used for in 1997? It was used for residential access to this parcel. Only residential. Is there any way my clients could have anticipated that Sandestin Owners Association would buy this parcel, given that it was disconnected by a lake? Absolutely not. What was the most logical, reasonable expectation? That this parcel would remain residential as with all the other uses around there. So my clients have a driveway that was facilitating access to what is now Sandestin's parcel for residential purposes only. Let me read to you what the court said. And I've given case citations. This is the operative law in Florida. There was no evidence presented which would show that at the time the easement was created, the parties to the transaction anticipated any commercial use of the property. So now what are we talking about? We're talking about at the time in which my client's parents carved out their property, which was being used for residential, and gave my clients the remaining parcel. So at that time, was there any expectation that this interior parcel that was being used for residential by my client's parents and by their brother, was there any expectation of commercial use? No. This is what the court held. Therefore, use by commercial tenants of the plaintiffs could not have been intended by the parties at the time of the creation of the easement. This court, and I say to you, this commission has no authority to expand the rights of the dominant estate. That's the one who's using the easement, and in this case, this would be Sandestin's use of my client's property, has no authority to expand the rights of the dominant estate to include commercial tenants. The next page, the court says, the law is clear that this court has no authority to increase the burden of the easement on the servient parcel. My clients are the servient parcel because the driveway runs across their property. So, with established Florida law, the driveway that has been accessing this parcel that Sandestin bought certainly could continue to have residential use and using the driveway. But according to the clear principles of our local jurisdiction, my clients do not have to be forced to deal with commercial use of their property. Why? It's an excessive burden. Not to mention the fact that it creates life and safety issues. Now having 65 plus, who knows how many, people coming up and down on their property. Again, this case was brought by the Reeves family, and they were told, yes, you can continue your residential use. No, you cannot do commercial. Your commercial use cannot use this easement to the beach. I think if I haven't made it clear to you, I'm just going to point out what I mean by such a significant change in scope and use that Sandestin proposes to my client's property. You've seen the meandering driveway. Sandestin proposes to construct a two-lane driveway. But of course, there's a power pole. So the two-lane graded driveway is limited by their own plans due to this power pole. As shown on Sandestin's plans, they have 11-foot wide driveway for access on this particular point. Now, Sandestin wants to also install utilities as part of their development application, which would mean they want to dig up my client's property. But my clients are saying no. Our local court has told us that a use of an easement cannot be expanded beyond what its original scope was when it was granted. Sandestin had all the tools, all the information available to it prior to purchasing this parcel. As Mr. Vorbeck said, they spent considerable due diligence. At what point did their failure to do their homework, to read the case that's actually cited in their title policy? Let me just point you to Exhibit K. This is Sandestin's title policy. Parcel 1 is my client's property. It references their deed. Had someone taken the time to look at their deed to see there was no reservation language? Obviously not. Had anyone taken the time to read the order referenced? Order recorded official record books and the amended order? I guess not, because had they read those orders, they would have read the same thing that I just read to you. Did someone at Sandestin not at some point think to themselves, there's a power pole that limits access, and there's a driveway that has no connection to what they claim to be a 20-foot wide easement? At what point were they obligated to come to my clients and ask, is there an easement? Where is it? Can I use it for commercial purposes? They didn't do that. They bought the property, and now they want to inflict a 9,000 square foot building with 65 plus people coming and going on their property at all hours of the day and night. Remember, Sandestin has security. They have people that have staggered hours. So now we've got traffic at varying hours. Middle of the night, mornings. This is excessive scope and an undue burden on my clients. Given the county's historical treatment of applications of this nature, given what I read to you from the county attorney and my experience with mutual clients with Mr. Davis, I ask that the county respect their traditional decisions, and in this case, deny any portion of the applicant's development order that affects my client. Why? My clients are property owners. They haven't consented. My clients do not approve of an expanded use or scope of a driveway on their property. And for you to decide to grant the application without limitation as it relates to my client's property will be a violation and a denial of their due process rights. I don't think it's fair in this situation to force my clients, because you make a decision, to have to sue Sandestin. Any questions?
Any questions?
I might.
Do you want to take a short
Yeah,
break?
I might have a question. Yeah.
Oh, you got a question?
Yeah, let me make sure. I wrote some notes down here. I guess my question would be, the person who sold the property to Sandestin, did he have the right to let them have access to this easement? And if he did he give them that right through the sale of his property?
Of course, our position is that there was never a valid reservation of an easement. So in answer to your question is, did he have a right to guarantee access to the parcel? Sure. But what was the purpose of that access? Residential. And where was that access? Along the driveway. I think you can say, simply summarize it, it was an access by necessity, because frankly, at this point in time, the parcel's landlocked. So there is a necessity for this meandering driveway to reach its way to each of the residential units. So did he have the authority to sell the property with residential access? I don't dispute that. We wouldn't be here if someone had purchased it for residential purposes. Did he have the authority to grant an easement for commercial purposes that changed the entire nature and scope of the access? No. That's why the title policy is so important. That's why that was the last catch-all for Sandestin to have realized there's a problem.
Okay, that answers my question. Thank you.
I don't. Oh.
Yes, ma'am. We got some wanting to take just a 10-minute break, so we're
Just
going
need
to
a
take
short
just
break.
Very good.
yeah. We'll take a 10-minute break.
I'll ask him.
Guys, okay. Let's come back to order.
She's out.
Let's come back to order. Miss Crew? Miss Crew? Did you?
At this point, we would like to have our experts,
Yes, ma'am. Yes, ma'am.
unless you have any questions of me, feel free to ask me any questions at any point in time, my clients as well.
Okay. All right. Thank you, ma'am.
Mark, I need to ask Dean Burgess a question, what to do when they're through with theirs?
Yes, that would be,
Okay.
Yeah, I do. I have a couple other questions for them.
yeah, when we get to rebuttal, that would be appropriate.
Okay.
I need those kind of chairs, you know, that you can turn and button and it starts massaging. That's fine.
Good afternoon.
Welcome.
My name is James Sullivan, 2507 Callaway Road, Tallahassee, Florida. I'm with Genesis Group. I am a transportation engineer, and I have been asked to look at the driveway for this project that's been discussed this afternoon, and to give you some additional information about the driveway access. As Ms. Crew had mentioned earlier, I have almost all of my career, almost 30 years, has been doing transportation design, highway design, road projects, both as a DOT employee and as a consultant. And so I've been in the roadway design business for a good long time. If I may, I'd like to pass out some of these reports, which I believe were already entered into evidence, but I have copies that I can refer to.
Mr. Volbeck, you have one? You got one from Mr. Volbeck?
Is this new information? Or
I don't believe
No, I
so.
believe this was actually in the last time we were.
Right. I won't go through all the material there, but I did want to briefly begin by talking about another report that was mentioned earlier that was entered into evidence, and that was the traffic report that was as a part of the application. Wanted to make sure that there was a distinction made about the traffic report, what its purpose was, and what information it provides. It was required as a part of all development orders to do a traffic analysis based on concurrency, and the report was done correctly, and it does accurately depict traffic volumes generated during the peak hour. And as was reported in that report and referenced earlier, the 13 trips were distributed half to the north and half to the south. However, the distinction I would like to make is that the traffic reports that DOT, the traffic volumes that DOT focuses on is daily trips. And based on our analysis, we're looking at somewhere in excess of 90 trips per day being generated by this proposed development. And what that results in is an impact on the driveway, and has already been described, there are improvements that need to be done to this driveway, and of course that triggers the DOT review and a DOT driveway permit. One of the exhibits that you can see there in your hand, or I will refer to, I'll hold it up here for you to look at, is a site distance exhibit. Now, I understand that the staff determined that this meets county's requirements for site distance. However, DOT takes a much larger view of site distance, and their minimum distance is based on the speed of the highway that the driveway is accessing. And as you can see from this exhibit, which is also included in the handout, there's quite a significantly longer distance that a driver needs to be able to see in order to safely exit this driveway. Now, it is a pretty clear sight distance line. However, there are some obscurities with trees and the power pole that was mentioned earlier. So that does increase opportunities for accidents, for that traffic exiting the driveway. So safety is a concern, and it will be a concern for DOT as they review a driveway permit application for improvements on this driveway. And it has been mentioned earlier, the driveway is basically limited to about 11 feet wide, which is another issue because the DOT's driveway criteria is based on those daily trips that we mentioned earlier. And the threshold is once a driveway traffic exceeds 20 daily trips, then the minimum width for the driveway is to be 24 feet. And it's physically impossible to put a 24-foot wide driveway in a 20-foot easement. So that presents some difficulties. And we have done some exhibits. You'll see the exhibits number 2, which is looking at the left turns out of this driveway, creating safety issues. And as traffic volumes increase on the driveway, the number of opportunities for traffic crashes increases. This is a fairly high traffic crash area, and DOT's traffic reports will bear that out. But as traffic volumes increase, the expectation would be that the accidents would increase as well. I'd like to point towards another exhibit. This would be exhibit number 3, and this is basically a blow-up of the driveway at US 98. There was some discussion earlier about controlling the type of access at this location. What we've drawn here is basically right turns in and right turns out in this driveway using a vehicle comparable to the size of a delivery truck. And you can see by either looking at your handout or by looking on the board that there are some difficulties even accessing a 24-foot wide driveway for a vehicle of that type, making a right turn in to this driveway. Part of the turning will encroach on the parking that is currently being utilized by the Footprints building and could present opportunities for accidents with vehicles backing out of parking at the same time as vehicles are turning right into the driveway. So it's a safety concern because of, I'm sorry.
I hate to interrupt, but he's talking about trucks, and delivery trucks, he's using that as an example. It's always stipulated for the record that we're going to get employees, and they don't drive delivery trucks. And so I think you're kind of getting out of an area that is even relevant because of that. I know you're liberal in your relevant determinations, but we're talking, you're mentioning trucks, studies about trucks, drawings about trucks, we're not dealing with trucks.
My suggestion would be the commission just consider for what it is, and that is an analysis using trucks instead of vehicles.
Thank you very much. And so I just simply want to point out the difficulties in making that turn into and out of a 24-foot wide driveway, which would be the minimum that DOT would require. The last exhibit that you have in your handout, we also looked at what it would take for a vehicle of that type to make a turn in. And it would take about a 36-foot wide driveway, which would, of course, include a large portion of the existing parking out there. But a vehicle could make the turn safely in a 36-foot wide driveway. But it would take a significant amount of the existing parking there at the Footprints building. That's all that I would like to share, but I'd certainly love to entertain any questions that you may have.
Any questions?
Not at this time.
Thank you.
Yeah, I do have a question.
Yes, ma'am.
This was looked at by DOT, correct?
Based on the staff report, yes, it appears that there had been conversations with DOT about this driveway.
And I guess, why wouldn't DOT make a more definitive statement? Because you made some pretty definitive statements about what DOT expected, and maybe they did, but I just didn't see them, of what they, what their rules were. If it was greater than 20 trips a day, it had to be 24 feet. Why didn't DOT make some more definitive statements about this access?
I can only suppose what they might be thinking. I don't really know. I haven't spoken directly with DOT about it, but my impression is that they are not going to make a definitive opinion until they driveway permit application has been received.
Okay. Okay, that answers my question. Thank you.
Pam Blackshear, President of Blackshear Planning. I am expert planner for the Reeves. And to keep you from having so much paperwork on your desk, it's my understanding that my revised report dated August 13th was in your board, and it's made part of the record. Mr. Davis, isn't it? Exhibit.
Let me make sure.
I have the copies that I can provide to you, Mr.
Let's see what's on the front cover. Yeah, I think we've got that, yeah.
She already has this,
Yeah.
so you can have it. We'll keep it over there. Keep it in my palm. I'm sorry, what are we doing now?
Pat's thing.
What are we doing now?
Do you need any other copies?
Is this what you're speaking?
No.
Okay, yeah, I might need another
Okay.
copy. I'm not sure.
I'm afraid you have the older one. This is the one that I did not get to present last time.
Okay,
I provided it to staff.
okay.
I can't find it.
Is that Exhibit R?
Yeah, but-
Again, it's the one that's dated August 13th.
August 13th? It's in our packet.
You got it?
No, it might be
No,
It might be in the book. I think it's in the
Because I was
book.
told
It's in the
we
book.
had it.
You know, and it might be helpful
Is it August
at some future date, Mr. Davis, if stuff like this was like indexed in these. And I know it's more work for the planning department, but it's,
Is it
For
dated
for the
August?
record, it is part of the record now. It was actually included in their books.
Okay, and that was what staff had indicated, so I went ahead and brought the extra copies just in
Thank
case.
you, yeah, good. It is in there.
Okay.
yeah, it's finding it.
Mr. Chairman, other board members, are we ready?
Yes,
Okay.
go ahead.
First of all, I'd like to clarify my point my report is I addressed the DRI issues as I see them, the comprehensive plan issues, and the code issues. I would like to address the fact that I still do not understand what happened at DOE. If DOE would have, in my opinion, done the right thing and done their job, we probably would have resolved all of this.
I'm sorry, DLE?
Excuse me, DEO. I keep seeing DOE. I don't think I'll ever be able to say, get away from DCA, but DEO, Department of Economic Opportunity.
Okay.
But they still have the same law and same rules for DRIs as they have always had. And to my knowledge, as I submitted in its exhibit in my staff report, and I did attach that, this type of project should have gone through a process where it would have been vetted with DOT. So my concern is just that this is an area along 98 that there have been numerous crashes. There was a fatality shortly after. We've had so many meetings now. The fatality was the week of June 21st, where a young man from Alabama was killed. So I am concerned because this is a design that DOT really doesn't favor or do much anymore, where you have the suicide lane, we call it, with no turn lanes, where you've just got to get out of this 6-lane traffic off of the road. And so that has been my concern, is the safety. That has been my concern, and the way that it's been reviewed by staff is because, in my opinion, that's the reason you're here, and that's why they are on staff, is because to review a project, the public safety welfare components of a code and plan are paramount. And I feel that all these points have been slightly overlooked in this review. And they should have been the priority issues is the safety of someone. I'm not going to get into ownership of the easement. That's Mr. Cruz's responsibility. But my point is that safety of the traveling public and anyone ingressing and egressing at that point on 98 should be the county's greatest concern. So with that said, I mean, that's my concern. If it had gone through the proper process, those issues would have been vetted. I have spoken to DOT, and DOT has basically been pulled back from the process because it did not go through DEO. Then when I spoke to the permitting staff, I feel that Mr. Sullivan gave you a very clear answer that I feel that they will vet those issues when they receive a full application. When I spoke to them a second time, they were continued to be called by the county saying, well, this is just a minimum impact. And I don't necessarily agree with that when that was some of my points in the review of the application is the traffic study is speaking of this very insignificant impact, but yet we still have not heard from the applicant as to what the actual impact will be. It changes every time Mr. Warbeck and his technical staff speak. So, we really need to nail this down, and it's my professional opinion, is that how can you approve anything beyond what has been considered and reviewed by your engineering staff in a traffic study? So I would respectfully request that that point be carefully discussed by this board before you take a vote today on this application. Moving on to the comprehensive plan and future land use map issues, this is Coastal Center. Staff has agreed with me that in Coastal Center, it does provide for supporting commercial uses. I have no argument about that. It does, however, have a provision, it's on page 2 of my report, workplace uses limited to offices, and it goes on to say without outdoor storage of materials and equipment. And I have not really heard a finite answer as to why 6,000 square feet of parking. You've got an 8,000 plus, building, and you're going to have 6,000 square foot of parking. So I feel that there needs to be clarification on that amount of parking. That's a lot of parking.
How many spaces is that, Ms. Blackshear?
Again, the application's not clear.
It's 20 spaces, it's good on the application.
That's Dean Burgess.
Sorry.
Okay, wait. We're gonna let them talk, and then you guys will have rebuttal. I don't wanna get into a back and forth.
6,000 square feet, then we can go from
Okay.
there. Thank you.
Thank you.
But one point that I've made about the comprehensive plan that is continued to be ignored by staff and the applicant and by the Planning Commission was that policy L110.5, and I'll read into the record, it's the bottom of page 2 of my report, business or commercial uses shall be prohibited on interior residential streets unless said uses are part of a recorded plat, an approved development order, or an approved neighborhood plan. The easement into the site is not part of a recorded plat, an approved development order, or an approved neighborhood plan. Use of the easement as the access to 98 is in violation of policy L110.5. The easement was granted to access single-family uses as an unrecorded family subdivision, where it was divided among the family and had, all the family members had their homes. Historically, there were the 4 rental mobile home units that had been there but had not been rented for many, many years. And had only, they had not been removed because of Mr. Reeves just being conservative, wanting to leave the most he could to his children. On page 3 of my report, I start talking now about code concerns and violations. The definition in the comprehensive plan, as Ms. Cruz stated, a change of use is very clear. A change of use is constituted when there is a change from one classification to the other, commercial to industrial, retail to entertainment, residential to commercial. So in the case of this site, it is clearly a change of use, residential to commercial, which would bring in all of your code and plan requirements. Again, the SOA major development order application for the office building consisting of 8,807 square feet is a commercial use. The current historical uses were limited to single family. Even, and this is where I think it's a little bit confusing for staff, even the 4 trailers or mobile homes that were rented were still residential uses. Those were not commercial uses. So this property, except the footprints building up front on 98, has never been used for commercial.
Can I interrupt you? I just want to make sure I'm clear. Is the argument that that section only applies to actual uses or the change in the land use classification? The section you're quoting?
It is the actual use, and the actual use is residential.
Okay.
Planners look at use. Just because you rent a home doesn't change the fact that it's a residential use. So, that is where, moving on to page 3 of my report, when you start into looking at the transportation requirements, my experience in this county and all other counties that I work in and where I worked as director and working with DOT, when you have a change of use, you meet the new standards for driveways and for, if it's a state highway, you meet those requirements. So again, in chapter 5, section 504, we start into my report on page 3 and 4, moving on to the very specific provisions of the design development standards that I feel have not been applied to this project. I've heard staff say, and the DOT was told, well, this is an existing driveway. Well, we have a completely changed site. We're going from single-family uses to office. And again, I'm still not clear on how many trips a day will go in and out this site, and I don't see how you could authorize any more than what was in the traffic report. Even the traffic report did not speak to the Kimberly Horn traffic report for the applicant. Did not speak to anything beyond, you know, these, quote, few employees. And it was based upon square footage and not employees. Didn't mention anything about any life safety vehicles entering and exiting, only for the office. And I've never seen an office that didn't have any type of deliveries. So, you know, that really concerns me that these very clear standards for the required planning, review of development proposals and plans for all single-family subdivisions, multifamily, residential, commercial, office, or industrial uses shall include appropriate consideration of potential transportation impacts related to the development through the submission of circulation, parking, and access plan as the code requires. Section 50402 gets into street classifications. I've asked that question over and over. How did you look at this driveway? What standards did you apply? All I have seen is simply, we've approved it. I mean, you know, a local street, it's not a local, I mean, is it a local? Is it a collector? If it's opened up to the rest of Sandestin, certainly it's a collector, and a collector would have a completely different set of standards that it would have to meet. But we've not had those answers addressed. The county has not answered that, and it is our opinion that certainly the parking area of the Footprints business would be significantly impacted, as shown by the engineer in his presentation with his graphics. Moving on to section 50403, the street designs again. You know, key issues on page 5. In order to reduce traffic congestion on the arterial and collector roads surrounding the development and to promote pedestrian environment within the development, streets shall be laid out, you know, with very specific standards. You know, we've not seen anything or heard anything from staff except we approve it. The visibility triangle, only we've approved it. What standards were applied have not been addressed. Access management on page 6 of my report, very specifically, all proposed development or redevelopment projects. Again, we have a change of use. We have use going from single family to commercial. It's a redevelopment project, and yet your code is very specific, all proposed, on my page 6, your section 50404, all proposed development or redevelopment projects within the county shall meet the following standards for vehicular access and circulation in relationship to the development site. You know, it doesn't appear that it's met any of these standards. It's just simply, you know, a one-way driveway out to 98 that is 11.01 foot, and I have photos in my my report that show that how can you move this road over, as was in testimony of Mr. Burgess, when you've got a power pole there, a 50, 60-foot power pole. I did speak to Gulf Power about this issue, because even if it could be moved over, set aside, you know, the legal issues about the easement for a moment, that's a major power pole that runs along 98. Let me give you the page number in my report where you can see the power pole. At the bottom of page 10 is a photo in my report. This is the power pole. This is within the 10-foot easement. When I spoke with the Gulf Power folks, they said at their minimum, because I said, do you have a setback from that power pole? You know, traffic is going to be entering and exiting. No, sure. Everybody understands we're talking about. This is the 20-foot easement. Here's the power pole. You got a billboard also that is just outside on the west property, but that's the power pole. So for us to say we're gonna just move this roadway over, well, it would require taking out a power pole. I haven't seen anything from Gulf Power that says we will do that. And Gulf Power told me that they would have to have a 6-foot setback. That would be the minimum setback from any traveling vehicular traffic in and out from that power pole. So that's the reason the road shifts over to one lane and is 1101 in width, is because they got to stay away from that power pole. So by staying away from the power pole, you're down to a 1 lane. And let me come back to the provision of the code that is violated. Going back to the bottom of my page 6. Access points from all local collector and arterial streets into the site must be sized to accommodate all vehicles which are reasonably anticipated to use the site, including delivery trucks. All access points shall either be exclusive 1 lane, 1-way drive, or minimum 2-lane, 2-way drive. Keywords: vehicles must be able to enter a site without encroaching on the lane of a 2-way driveway. So we know from the engineer's work that with any kind of vehicle approaching to turn in that site with no turn lanes, you've got to get out of that, Highway 98 onto the site. So it is our opinion that they're going to have to go right through Ms. Reeves' footprint parking lot. The next point is that, and let me just make sure that you understand, I say it in the beginning of my report, all the italicized text in my report is code and plan verbatim. And the next point on top of page 7, all access points must provide sufficient on-lane storage to accommodate queued to park or exit without using any portion of the street right-of-way or interfering with street traffic flow. So you've got traffic along 98 that there's no turn lane. It's just got to get off and come in 11.01 driveway. And you've got Miss Reeves parking, again, going back to the photograph. Miss Reeves, at the bottom page 10, the photograph, you've got Miss Reeves' parking area, and the yellow line on the photograph is basically the edge of the easement, and the larger photograph is behind page 12. And I put this in just so that it's very clear. This really is where they're going to be trying to get out and in. Okay, this is the edge of the easement. So this is Miss Reeves' parking area. So you're going to have traffic trying to cut in that small area, and I'm very concerned about the safety of all that movement of someone trying to back out, one of her patrons backing out, and someone trying to cut in, because there's nowhere, as the code requires, for that traffic to sit in a queue to turn. There's just simply not, it's just simply not there. And again, the reason that her parking is on both sides of the building as it is now is because their family gave the land for 98 to be 6-lane. That's the reason that her parking is on both sides of the building. When we had DOT to the site, they actually, some of them remembered when all that went on, and they understood that all that was grandfathered. So again, there's no space, as the code requires, for any traffic to sit in a queue, either on 98 or if somebody is on 98 trying to make that turn into that 1101-foot driveway, and if someone is pulled up that they can't see in the visual triangle, you're going to have a crash right behind Miss Reeves' patron's parking area. This is clearly, moving on page 7 of my report, it is clearly a major project. It's over 5,000 square feet. To my knowledge, there's been no variances applied for this project. It should meet all the code and comprehensive plan requirements. At the bottom of page 7, I start talking about, again, the italicized text is out directly out of your code. Submittal requirements for major and minor developments. Probably the most important component in that list of requirements is item 7. Identification of the land use designations and densities of land areas adjacent to the proposed development, and an indication of the relationship of the transportation systems of adjacent development to the proposed development. And I would submit to you as a professional planner that it is clear to me from this application that there's been no consideration by the applicant, assuming there were no legal issues on the easement, that they looked at how their traffic flow would interface and work with Ms. Reeves' footprints building, parking area, and the ingress and egress for her patrons. It is just, in the conversations we've had, it's, well, just tell Ms. Reeves to move her parking to the other side of the building. Well, Ms. Reeves owns that land. She's had her parking there all these years. Historically, they gave land to DOT. DOT approved that parking to remain there. So I think that the Reeves have not been treated very fairly in that regard. Again, this is the area I'm talking about. Most of you have traveled this. You know, my concern is, you know, I'm just as concerned for the SOA employees. You know, again, I do not feel that this is a safe ingress egress, and it does not meet the code requirements. So I question how staff can continue to say it meets code, it meets code, it meets code, and yet it does not meet the technical standards of your comprehensive plan and your land development code. And we didn't even see an application go to DOT until we continued to say, what does DOT say? Has there been a permit issued by DOT? Then we saw where there was the permit application filled out, and staff did provide that to me, but again, the owner of the easement didn't sign it. And to my knowledge, it has not been submitted to DOT yet. The other point I want to make about this is probably the worst location for this type of ingress egress. You have the footprints business, you've got their parking area that's making these turning movements and backing in and out in this driveway area. You have Hidden Dunes, that's an offset across 98 that is 450 units. Then you've got a lot of people in the audience that want to speak today, so I want to move on so they'll have time to speak. That they're concerned about their neighborhoods trying, the Gulf Pines area, trying to get out and in safely. When I was out there trying to get photos, I was zigzagging all over the road, and I would have to get out and in the road almost to see if a car was coming, and I was on foot. So,
yeah, I'd like to object. We already stipulated we do right-hand turn. There's not going to be any of that. For the record.
again, as a professional planner, the other point is that their agreement about making a right in, right out has nothing to do with the grandfathered in parking of the Footprints building that's owned by the Reeves. They do not have any limitation on them about the right in, right out. So to move on to my conclusions, again, it is a change of use. It is a major change of use. It is from single-family use to an 8,807 square foot office building with 6,000 foot of covered parking. It cannot have any outdoor storage. So again, that's still unclear to me why you need that much covered parking, unless it's to try to store some type of equipment that can't be done by the future land use category. It should have gone through an NOPC, and these issues would have been vetted properly with DEO and with DOT. It is Absolutely, your code calls for all development or redevelopment to meet the code requirements. Doesn't provide any flexibility or variance to it meeting the code. Again, you're talking about trying to provide ingress and egress to a site with 11.01 driveway. There's not sufficient on-site storage area for anyone trying to prepare to turn, and someone could be coming in on them. Again, a one-way 11-foot driveway is not a good design for this kind of access point on 98. The applicant, in my opinion, failed to clearly articulate in the application to staff about the impact on the Footprints parking lot and their ingress egress. And I don't feel that staff has adequately looked at that relationship of the traffic from the proposed traffic from the SOA facility and the traffic and turning movements of the Footprints building, and I feel that should have been done. That was a responsibility they should have done in their evaluation. And I feel there needs to be clear disclosure before this board today and for our client as to what are we really talking about. I have heard it initially started, we were gonna have just a few employees. We were gonna have 13 employees. Then their testimony came out, and we've got 7,000 or 8,000 people with cards that could go through a gate. Staff was telling me there's a gate. You got to have a card to get in and out. Then it turned into 7,000 or 8,000. Then we brought it back to, well, now it's just a few employees. The building can occupy 68 people, according to the architectural plans. So what really is this? How many people will really be using this facility? And I'll stop with that. In closing, that this application is designed and before you today does not meet your comprehensive plan or land development code.
Any
Chairman,
questions?
I have a question.
Yes,
Yes,
ma'am.
I have a question. Ms. Blackshear, did the developers of this property, did they meet with any of you all or meet with Ms. Reeves at the onset of the project or ever during the course of the project? Did y'all meet? Did they?
I think they had, I'll let the Reeves speak to that because it would be hearsay and I know they're going to speak. So
Okay.
They did
Okay.
talk to them, but I was not in that meeting.
Okay, okay.
Ms. Blackshear, I want to make sure, I had one of my notes I wanted to ask Dean Burgess, and I think you answered my question. You're saying that Gulf Power says they cannot or will not move that power pole?
They didn't mention moving the power pole, but they did tell me that wherever the power poles are, there's a six there, and it's not a written code, but their guide that they use when they review projects is that any traffic must be at least 6 feet away from their power pole.
Any other questions? Thank you. You want to go to, what's your, Ms. Crew?
My clients, the Reeves, would like to address the commission. Also, you asked a question about the parking. In the applicant's March 2013 application, project information, number of parking spaces, 30 plus 20 covered is what they represented.
30 plus
Okay.
20 covered. 50 spaces.
State your name for the record, sir, before you get started.
My name is Doyle Reeves.
Okay.
I am qualified to speak on the property for many reasons. I have lived on the property for the past 51 years and still do. Our home is on the property. One of our sons and his family and our grandchildren, some of our grandchildren live on the property. It is our property that is proposed to be modified both in its physical condition, location, and use. My wife Janet and I own the property where SOA intends to construct its new driveway, run its new utility lines to use for commercial purposes. I want to go on record here as the landowner that Janet and I have not agreed for SOA's pending DO application, and thus the application is incomplete because Janet and I, as the property owner whose land is affected by the DO application, do not and will not consent to it. Janet and I live on the property adjoining the parcel, and we have 9 grandchildren and soon to be 10, ranging in ages from 1 to 12 that are playing on the property. SOA's commercial use of our property is going to put our family's life, safety, and quality of life in jeopardy, and that is not acceptable. My mom and dad bought the 8-acre tract of land in the mid-50s and lived on it continuously until their death. I was blessed to live on the property with my wife, Janet, to watch and help my parents grow old together. I thank God every day for that blessing to be with our family and to be a caregiver for them. I stayed at my mother's side the last night of her life up until she took her last breath. My wife became a daughter to them. They made memories with our children and their grandchildren. They had many opportunities to sell the property, but did not because they wanted it to be our family neighborhood. My dad was always my best friend. My son, his wife, and their 3 sons live on the property. 9 years ago, my brother built a house there and said that one of his 2 sons would also build a house next to him. We all use 11-foot wide, single, meandering driveway to access our house. We used to put pine straw in the driveway to keep the dust down. All of our family understood that that was the driveway we would use to go to Highway 98 and to go home. My parents, in order to supplement their Social Security check, had 4 long-term residential mobile homes that was only rented for yearly rentals. The same as renting any residential house. As their health went down, they were unable to keep them rented. By the time my dad died, there were only 2 rented, and Mother stopped renting them. Soon after his death, Mother was not able to keep the mobile homes, so they stayed empty for many years until we found someone to dismantle them for scrap metal. I'd like to clear up a misrepresentation of SOA as a previous meeting. SOA tried to misrepresent there was commercial activity on our property. There has never been any commercial activity on our property except footprints. The back part of the property has never been commercial, only residential. The only trips made to Highway 98 was our family and residential trips. DOT paid for a new house for my parents, and the taking of Highway 98 frontage and the access to their home was through a meandering 10 or 11-foot wide driveway that was next to the 10-foot deeded easement that Gulf Power has on the western boundary of the property. The single car 10 to 11-foot driveway was always been sole ingress and egress for the 2.6 acre parcel, and it did not connect to the 2.6 acre parcel until the first residence in the southeastern corner, which was my mom and dad's house. The 20-foot wide easement along the western boundary must have been in error because the only easement along the western boundary is a 10-foot Gulf Power easement. It is interesting to know that SOA was like a thief in the night to tear down my dad's brick shop that DOT built for him. The building backed up to the Gulf Power easement, which made it clear that the 2.6 acre could not be accessed because of the brick building. So they knew when purchasing the property, the only access to it was through the meandering driveway that did not connect to the 2.6 acre parcel. The only easement to the 2.6 acre parcel was an easement by necessity and by verbal agreement limited to the historically existing meandering driveway. No one in our family ever considered 20-foot easement as a driveway. We never agreed to a formal binding 20-foot wide easement. My mom and dad never created a formal binding easement by reservation. In '97, when my parents granted us the property, my dad did not reserve any easement in my deed. This is because it was always understood between my parents and Janet and myself that the meandering driveway, which Janet and I own, the meandering driveway would be the only source for residential access, and that we would always allow this driveway to be used for residential access to the 2.6 acre parcel. It was discussed between my parents, Janet, and myself that this driveway would be for residential purposes, never for commercial. The driveway existed in its present location for decades, 10 to 11 foot wide meandering driveway. At no time in the past decade did the driveway location change. It remained the same location and the same width. All of the surrounding properties were residential, and our family always intended that the northern 2.6 acre parcel would be used exclusively for residential use, as were the other surrounding parcels. After Dad died, Doyce, my brother, and his wife moved into the 2.6 acre parcel, used it exclusively for residential purposes, and they always used our meandering driveway for ingress and egress. There was a lake and wetlands along the northern end of the 2.6 acre parcel, so there was never any thought that it would ever be used for anything but residential. In '92, DOT took all of our highway frontage when it widened Highway 98. This left the 2.6 acre parcel with 11 foot wide driveway. DOT and the county allowed this driveway to exist even though it wasn't code compliant, which means it should have been 24 feet wide, because it was grandfathered for residential use only to the 2.6 acre parcel. In '97, when my parents split up the property and kept the 2.6 acre parcel for themselves, we had a family council meeting with my dad, my mom, Janet, and myself. We discussed their intention for the 2.6 acres, that they wanted it used for residential use, that an easement by necessity for residential access was verbally created, and it was always intended that the meandering driveway was the sole access to the residencies, that the driveway would remain as its existing condition of the width of a car, 11 to 12 feet wide, and that its use would be limited to few residences on the parcel. When SOA purchased the 2.6 acre parcel, SOA could easily see that the only access to that parcel was via the meandering driveway that connected to the 2.6 acre parcel at the southeastern corner. SOA obviously did not do its due diligence before buying the parcel, because if they had done their homework, they would have realized it was impossible for there to be a 20-foot wide easement along the west side. One, because there was a pre-existing 10-foot easement for power poles, and they have always been the power poles in the easement. The SOA would have seen that their access is only via the meandering 10 to 11 foot driveway. My dad had a workshop that completely blocked the west side. As a matter of fact, the SOA tore down that building before anyone would have time to point out it came up to the edge of the Gulf Power easement. So there was no way to access the 2.6 acres except by the Gulf Power easement. SOA was put on notice that there was an access issue, and they chose to ignore it. Plus, SOA was put on notice about the ruling in our Hidden Dune lawsuit. Janet and I was personally involved in the Reeves versus Hidden Dunes litigation. The outcome in that litigation sets the precedence for the outcome of SOA's use of the driveway of our property, and that is, it can only be used for residential purposes, which was the intent when the easement by necessity was created in '97. It is limited to the few residencies of the 2.6 acre parcel. That is why the driveway on our property can only be used for originally intended purposes. SOA cannot change that use. SOA is trying to change that use by making it a 2-lane driveway that has no relation to what it historically existed. It proposes to raise the grade of the driveway and asphalt it. It wants to install utilities on the property. It is changing the use from a few rental cars to a lot of employee commercial vehicles. That by law, SOA cannot overburden our property, and that is exactly what it proposes to do. It will be like a freeway of cars traveling at all hours of the day and night down the proposed driveway. SOA has changed the use of the 2.6 acre parcel from residential to commercial, and the commission, by its own laws, is required to make SOA bring the entire project up to fully to code, including the proposed driveway. And I will not allow this to happen. Janet and I have done everything we know how to do to explain how dangerous this intersection would be to bring traffic onto the Highway 98. Anyone turning left would be in a Hidden Dunes turn lane, and traffic from Hidden Dunes turning left would also be in the suicide lane. I'd like to draw your attention to the first picture. It's in the handout attached to what I'm reading. If you look at that, Hidden Dunes across the street, you know how the two cars would collide in the center. And they have a lot of traffic coming out of there. I've been driving that road for 51 years, not 51, 46 actual driving, because I go back to my being a kid. But I'm telling you, this is very dangerous the way that's set up. And when you try to cross, a lot of times cars will be turning into Hidden Dunes in that turn lane, and you're trying to go left there, which that is a big issue, or even if you're going right into that. So that is a big problem for traffic, and there will be some problems in that one. An SOA contractor has already proven, is in front of the collision that happened. And if you look at the picture on the very last page, this is a first SOA contractor that has been coming out of that driveway that I've been telling everybody how dangerous it is. If you notice, it's, you know, I heard Mr. Vorback say a while ago there won't be any delivery trucks. We look at this one. It's a truck, and it's got a long trailer that takes up the whole 3 lanes of the road there and going out. And so he did a head-on collision with a car coming from the Sandestin area, red light area. I went up to the driver after the wreck, and I said, "What happened?" He said, "Well, I didn't see the car coming." But if any of you know driving on that road, how hard it is to see them, especially if you're pulling out from that driveway. You got a building there, and you got on the other side of you some more building, the restaurant next to it, which is a major problem trying to pull out there. Then on June 21st, for about 400 feet from this intersection, as you can see a handout I gave you also, that's the first fatality we had this summer. It's on June 21st. So that was a Alabama man was killed in a crash there. And this was 3 lanes. Any of you driving that road this summer know that road has been packed with 3 lanes. I mean, just solid cars constantly. And I can't even imagine that SOA would be wanting to try to bring traffic across that road. You know how much traffic is on there. Then I have a first responder report also attached. And this I got from the fire department. I asked them to give me any of the accidents that... Okay, if you'll keep listening, you might hear it. I had a first responder report.
Sir?
Yes.
Just don't make no
Well, he
comments.
just
I
interrupted me. I
understand.
don't appreciate him interrupting me.
Everybody stop.
Yes.
Mr. Reeves,
Yeah.
Mr. Vorbeck made an objection.
Okay.
So we've heard the objection, now you can continue.
Okay, I'm not in a court of law. I just like to say I'm not used to somebody objecting when I'm trying to talk. So I'm not trying to be rude to him, but I'm sure he might be trying to do that to me. But anyway, this is from the fire department. I got this report, and you can see there's 12 accidents between the Sandestin red light and between this outlet mall red light. I requested that, and that's how many you can see. Obviously, one of those, June 21st, was the fatality that happened there. But that's just to show you how busy, just a short period of time. That's from June the 16th to July the 17th. So that's just a short period. This summer, we had all those wrecks there. And if you dump all that traffic, if they're wanting to throw in there, there's going to be a lot of deaths involved in that. I've hired Jill Crew a great attorney she is, and Pat Blackshear, as you know, is a professional city planner, along with traffic engineers in Tallahassee, to try to explain how dangerous this intersection is going to be. And I'd like to just give you an example of how broken the system is. I called the Florida Department of Highway Safety in Tallahassee and explained to them what the SOA is trying to do. If you bring this traffic onto this road to that intersection, there's going to be all kind of problems. Well, they handled it very easily. He said, well, you need to call DOT. That's DOT's problem. Well, I called DOT, and my wife did, called DOT and explained the same thing to them. And he said, well, that's the DEO's problem. You got to call DEO and talk to them about it. So my wife called Anna at DEO and explained it to Anna the same thing, how dangerous this is, what they're trying to do. Well, another organization said, well, you got to go back down to the county. This is really a county's problem. We can't really do anything. So it's a federal highway that none of the state organizations wants to take charge of and be in control, and they're putting it all back on you as county commissioners. But the problem I've got with that is that I feel like there's been so many code violations, and so many of the planning and zoning have ignored all of the different things, it's in violation of. So if we're putting it back down the county and they're ignoring these, we have problems. But I want to go on record today for future legal inquiries that will be made, that we have done all that we can do to tell everybody how dangerous this intersection is. My legal advisor has told me that I, as a property owner, am liable for any accidents that happen there. And that's not acceptable to me. I don't want to be responsible if somebody has gone out there and got killed, in that intersection, because we've done everything I know to do. And so what we're going to have to do is to be able to, make sure that any opposing attorney will get a copy of everything that we have done to try to do it. But the bad thing about it is, for the county commissioners, this is going to end up, you're going to be the deep pockets on this. If you approve this thing and let it go through, I've done everything I know to do. I'm not the deep pockets. I don't have enough in liability cases, and there will be a lot of them. This is going to be a big problem for the county and the taxpayers. In a previous meeting with the Planning and Zoning Board, I asked a member of the council, why did you pass this thing through with all of the violations? His answer was, it was not in the paperwork that was presented to me. The question for you and for the county is the staff doing their job? Are they giving and presenting all these code violations? In a meeting that Janet and I had with one of SOA members, his name is Joe Braxelli, and Janet and I both met with him, so it's not a one-person interview with him. He told Janet and myself that Sandestin always gets what they want because they are Sandestin. They have many millions, and I won't tell you how many millions. He did share that number with us, but I don't want to embarrass him by saying how many millions. I think the homeowners would be surprised if they knew this. They have many millions of dollars to make sure that happens. If anyone opposes them, they will keep them tied up in court. I'm asking you as the county commissioners to protect all of the people of Walton County and show Mr. Joe that everyone has to obey the county codes and the Florida statutes and the law. This should not be passed because it violates so many codes and is changing the use of the property from residential to commercial. A DO cannot be issued because we, as a landowner, will not approve it. There has already been a case ruled in Walton courts that was pointed out to Mr. Mark Davis, the county attorney, where the Walton court could not allow Crazy Carl to change property use or modify use without a property owner's approval. If you don't rule as you did in Crazy Carl's case, then I'm afraid there will be a discrimination charge that we will have to pursue. But I'm asking you as the leaders, don't drop that don't put the traffic out there in that road the way they're wanting to do, because if you take all of these number of cars and vehicles and SOA employees, supposedly the contractors they want to dump them there. And sure, they're saying today, we're not going to do that. But we know that we're not going to do it. It's going to be tomorrow. They will be, oh yeah, we're doing it. So don't let them dump all that type traffic on that road, because that it is too dangerous. Any of you knows how the traffic is there. I thank you for your attention and listening to what I had to say. Does anybody have any questions?
Any questions?
Yeah, I have a question.
Yes.
Did y'all, now, Joe Braxelli, is he you said he was one of the Sandestin Owner Association members, so he's a resident there? Is he on the SOA board?
He is. He lives in Sandestin, and he came to our house and talked to us when they were originally trying to buy the property from our brother over there. He came and talked to us at our house at that time.
Okay, was he representing the board, the SOA
I'm
board?
not sure how he represented himself. He just
Okay.
represented himself as being part of the.
Okay. Did
of
they
their
ever?
group.
Did they ever?
I think he's a realtor for them. I've learned later. I didn't know that at the time.
Okay. Did they ever come to y'all and present a plan to y'all and show you what they were going to do and talk to y'all about that? Was that ever
No, they did
something
not.
that they did?
No.
Okay. And how did you find out that this was all going on?
In which regard?
Well, how did you find out that they had bought the land from was it your brother?
Yeah, I bought it from my brother.
From your brother, and that what they were
I found out from my brother that he was selling the property to them.
Okay.
Then we started guessing, well, what are they trying to do?
Okay.
You know, 'cause we were concerned. There's a Florida, what do they call it, utility easement on one side of our property where they got the drainage pipe from the highway and everything, that they're going to try to access that next to our house. And we were just trying to find out, what was going on.
Did you ever have any conversations with your brother about access, or how did they about access?
I think he was too happy to sell the property and to leave, so I don't know. He in his all justice, he lost his leg from diabetes, and I think for him, any money that he could get was helping to further his, protecting his leg and his life. So,
Okay.
So he was just too happy to get his money and to leave.
Okay. I think that's all the questions I have.
I have a question of Mark. They keep referring.
Thank you, sir. Thank you.
They keep referring to the Crazy Carl case. Does it have any bearing on this case at all? Mark?
To be honest with you, I represented a lady named Nina Porter Atkinson, who owned
Yeah,
the property
remember.
behind Crazy
Yeah.
Carl's. My recollection was somebody from the county, that might have been Lynn, called me, and I at some point wrote a letter to Jill, who was representing Mr. Fireman at the time. They asked, did we have any objections to somebody improving the access? And my recollection was we objected to the improvements to the access, and that's all I remember,
Okay, but,
frankly.
and I remember it because, but does.
And we might have even had something before all of that about Mr. Fireman blocking the access. I think there might have been some letters or something before that, but that's all I remember.
I remember it.
I know
you know.
something about that.
Yeah, because we're still, I think that's, planning is still working on that project. But I'm asking, what does the one have to do with the other, or does it?
I don't know. I don't
Ms.
remember.
Crew,
I don't
Ms.
remember.
Crew, do you have anyone else?
I can tell
Do you have
what I think.
anyone
Yeah,
else?
I don't remember the details of
The
Do you have
details are
anyone
that
Yeah.
he's got a commercial use, and the access to his commercial use is off of an easement that is a residential easement owned by the person in the back.
Right.
And the county said, well, in order to really get your DO for your commercial, you really need to improve that entrance off of thing.
You're right.
And then they said, well, in order to do that, you've got to get the owner's approval. And the owner living in the back would not give the approval. Therefore,
Yeah, I remember
he could not improve his driveway.
Yeah,
That was,
And I think DOT refused to let him have another cut. I think that's, so I just wondered
I
what one
think
case
that-
has to do with the other.
isn't
I believe
83
since you've been-
Isn't-
That is
Yes.
accurate,
Yeah.
because they
They
didn't
refused
want
to let
another
him.
driveway so close
Yeah.
to Mrs. Atkinson's driveway,
Right.
Nina Street.
Yeah.
right.
I have Mrs. Reeves, and then Alan Osborne would like to testify to an exact situation as to the Carl Fireman issue, where he was denied a development order because he was not able to get the permission of the easement owner to make the improvements necessary. So
Yes,
the Carl
ma'am.
Fireman issue is one of several examples of the county's consistent treatment of getting the approval of an easement owner, the property owner.
Okay.
My name is Janet Reeves. They've asked me to try to cut mine short, and since I'm not a professional speaker, that's going to be difficult, but I'll try, so bear with me. I just wanted to show you how small the driveway is. It's really hard on some of those pictures to see, but you know, they're acting like there's so much room for that to be used for commercial use, and it's so small. And another thing that I would like to correct is my husband was asked the question by Cindy Meadows, had they met with us? They met with us. They said they would like to show us their plans. And in that, they showed us that 9,000 square foot building, and they told us that they wanted security on the property. They said nothing about our easement. And Mr. Vorbeck keeps stating that they've tried to work this problem out with us. We have not been contacted for one approval, one time to show us what their situation was and what they were looking to do. Not once. Not once. We're the owners. They will ingress and egress at our pleasure. They are acting like we have no say-so in this whatsoever. It's maddening to think that they can just go ahead and tell you that they're going to put a 2-lane road in here and not even mention it to us, not even show us saying that this is a good thing for you too. Go ahead and do this. You know, you want to do this. Not one. They've not asked us to sign anything. They're acting like that they've tried to work with us and that we have been obstinate. We're obstinate, but not for the reasons that he is saying. We don't want a commercial road in and out of that little space. It is going to harm my business tremendously. The county, the DOT, when they took our out front parking, they gave me 2 curb cuts so that I would not lose business. And that west side driveway is essential to my business, because what happens is the people are traveling so fast on that road. My shop is an impulse buying shop. They see it, they like it, it looks cute, but they're going too fast and cars are pushing it too quickly to be able to turn into that first parking lot. And so then they make it into the second one. And then the people who know us and come back year after year, they know to pull into the east side parking lot. Mr. Vorbeck has also acted like, well, the Reeves have 2 other easements. We don't have 2 other easements. I have the parking on the east side that's essential to my business and the parking on the west side that's essential to my business. And we have a 1-lane, 1-car garage that we don't have room to expand to a 2. There is no room on the property to expand to a 2. We have always parked the cars that we use most of the time on that west side driveway and use that. That is what we have used for decades. So he's trying, I mean, it's also maddening to us as a homeowner that they're trying to tell us how we should use our property. Would any of you want to be told how to use your own property? We don't mind at all their business going back there. We know that we could fight them on that because it is residential. We have. He tried to also say that we did not have a platted, that all it was a platted piece of property or something, that it was not residential. Well, we have 14 addresses on our property. We have an 8-slot mailbox on our property. Our address is 75 Reeves Road. My brother-in-law's was 161 Reeves Road. My son's is 60 Reeves Road. My mother and father-in-law's is 55 Reeves Road. So if that doesn't tell you that we already have a neighborhood there, a family neighborhood, then, you know, why is he so deceptive about all of these things? We don't understand it. This has nothing to do with what is in the codes that you should be ruling on. We are really bothered by this. But my my driveway and my parking lot on the east side is adequate. My parking lot on the west side is just barely enough room. According to the current codes, you have to have a 20-foot space for the car to park and a 24-foot space for these cars to back out and turn around. Well, that leaves that 11-foot driveway and that 10-foot easement for Gulf Power. There is no room for them to do anything but have a little lane there. And that little lane was meant for residential use only, for probably a maximum of 6 or 8 houses in that 2.6 acre spot there. And they are trying to run over us. And it's, I'm sorry that I'm emotional, but it's our lives. We plan to die there on that property. We've lived there all our married lives. We've lived in the very same house for 43 years that my husband built for me. And we don't have any desire to make money off of it, which is another issue that Mr. Vorbeck continues to misstate over and over again. Our property has never been for sale. He keeps saying that we had it up for sale. We had a 6-month contract with John Summers to lease the front part of the property. I have a statement here from Mr. Summers that said that if anybody says anything differently, that was an error. What happened originally was that he put it out there as the whole 6-point-something acres, and he got it confused with my brother-in-law selling and us leasing. And we immediately, my husband went out there and took that board down, and he put up the correct board, said that it was a land lease. So if you see something by Mr. Vorbeck that shows that this property was ever for sale, it has never been for sale. I want to speak to you about the liability. Well, let me go ahead. I've got one more thing with Mr. Vorbeck's misstatements. Hold on. I've covered that one and that one. Another thing that has been maddening to me is because my husband and I have tried so desperately to get these boards to understand how dangerous Highway 98 is, as if you didn't already know. And we have submitted pictures showing accidents there. In the summertime, I literally took pictures every day of accidents on that stretch of road between Silver Sands Outlet Mall and Sandestin Resort. Every single day there's an accident. Almost every single day the traffic backs up beyond my business from Silver Sands red light there. And Mr. Vorbeck makes this 2 or 3 statements about how insignificant that is to this issue. It is the total issue. The total issue is traffic, safety for the citizens and the visitors that come here. And he is trying to minimize that. And I just don't understand how he can do that. Another issue that I don't think has been adequately brought up or specified is that the tremendous liability that we have. Initially, we were trying to be a good neighbor, and we said that they could have emergency vehicles go through there. Then we found out about the liability that we would have to allow their 13 staff, then it was 7 staff, then it was 20, then it was 96, or whatever it winds up being, and the emergency vehicles. But we will not allow that because of the liability that we will have. We know that most of the emergency vehicles come from Mac Bayou Road and Santa Rosa Beach, and that there's no reason why they can't enter into their 2 other exits and take care of any problems that are there. So we want you to know that we will not give them any kind of accesses. We know their history. We know that they take advantage. And when I talk about, I'm not talking about the people of Sandestin. I'm talking about a few people on their boards that control everything. I know that most people in Sandestin are very nice people. So I thank you for your time.
Thank you. Any questions? Ms. Crew, you have anyone else?
Mr. Alan Osborne
Okay.
would like to give you a similar example of Carl Fireman.
For the record, Alan Osborne, and I'm not here on anybody's behalf tonight. I'm here for equal treatment of citizens. I'm not on their side, and I'm not on their side, but I can tell you this. I came before this board with a Sandestin issue, and it had to do with the road. And I had the easement, and you have a plat that says I have a road there, and it's been approved by the DEO. And before that, it was approved by the DCA. It's on record right now. And I came in here with a development order to rip that wall down and build a road over that with that easement. And what I was told is the SOA owned the land underneath that easement. And this board and the county would not grant me a permit. I have that application. I find it ironic that the Sandestin Owners Association wants to do the same thing they told me I couldn't do. They claim they have an easement, and they've come up here and done this, and what this is bullying, is what it is. If your policy has been not to, if you want to issue a permit for them and just let it go to court, then issue a permit to me and I'll tear down a wall and we'll let that go to court too. But that's not what happened. The county said it was their policy that the landowner had to give permission. And SOA was the landowner underneath that easement. Now, how can this be any different? It's exactly on point, and it's exactly consistent with what you've done in the past. You can't do special treatment for special people because the SOA is not special. It's made up of individual homeowners with individual rights. And just because they collectively pay to an association for recreation gives them no more entitlement to the county code than it does to a single family owner like myself or these people. I don't personally know them. So in consistency alone, how can you deny somebody for the exact same reason that these people say they're not going to grant permission for them to come across their property? Aren't you impeding on their rights as private property owners at that point? And it goes back to the fundamental question of, are you going to enforce your codes and ordinances or not? You got a master plan, and they've had every opportunity for 20 years to incorporate somewhere in that master plan to have an SOA without going through these people's property. And there's been plenty of other accesses to you. They told you today the reason they want to move is the rent's too high. Well, that's not these people's problem. That's a planning issue that has to do with the so-called declarant and the so-called SOA ownership control issue. That's not an issue for these people's private property. You've got a master plan adopted and it doesn't have a road there. You got an ordinance adopted and it doesn't have a road there. You got references, not all this property is within the DRI, but I believe the building is. And if that's the case, if it affects traffic within that DRI, no matter if there's 2 square feet attaching to that DRI, it ought to be part of the master traffic plan. And I have sworn depositions from your staff saying that you don't have a comprehensive traffic study conducted since 1984. Now, do you think we look like we did in 1984? We don't. And you shouldn't do anything else with Sandestin until you demand a comprehensive NOPC, a comprehensive traffic plan. But it doesn't change those facts. And the fact is also, commercial is not residential. That's also defined in your ordinance. I believe it's 2002-18. I didn't come prepared today. I think it's like paragraph 24 or somewhere in there. And it says in there that those are defined as changes from types of use. And why does anybody deserve to have a commercial strip put down through the middle of their residential property? Now, I keep hearing names like DEO, DCA, and the traffic, but in reality, commissioners, have you ever been to those offices? There's 5, 6 people sitting around the DEO office trying to approve everything for the whole state. basically in there. There's Mr. McDaniels and Anna Richmond and some of those people sitting in there. But you are the most important part of that factor because they trust you, the local government, because it's required by 380 to do local monitoring on these big developments. I haven't heard the word PUD used today and very little DRI. But Sandestin was adopted as a PUD in '86, and this traffic plan's not part of it. And that overlay is not current. But I'll close with this. You denied me the right of an easement because you said the owners wouldn't give me permission. Be real careful that you don't exercise that justice and those decisions fairly, uniformly against all citizens and give no preference to large groups. Because they don't, by the Constitution, large groups don't get preference. Individuals have the same rights, no matter if they're on that side of the easement or that side of the easement. They should be treated fairly. Thank you.
Ms. Cruz? Are you?
No further witnesses, although I understand there is some public that...
Yes, ma'am. We're going to take another 5-minute or 10-minute break. I don't know how to get you to stand up.
What's the process from here? More back gets done.
Let's come back to order. Let's come back to order.
Well, the applicant's gone.
Yeah, well, see, nobody here.
So I
Let's
guess-
go, let's leave
I
too.
guess we have to go.
Who's been playing with my foosball?
Is this for stress?
Yes.
It is, because like,
Yes,
if
we
you
try.
notice, like when people are talking, you can just go like
Squeeze
this.
it.
I didn't notice that before.
Sarah showed it to me.
Yeah, see me, your eyeballs pop out.
She's used to squeezing people's heads.
His name, the one that's asleep, his name's Larry Jones.
Oh, yeah, you ought to give it to them. Oh, they'd love that. What,
Larry
Mark,
Jones.
what is
Larry
the,
Jones.
what do we got left?
Yeah,
Public speakers and then rebuttal, and then we're done.
yeah. He's county administrator. But I don't think
Yes,
Larry
sir.
Jones.
Mr. Volbeck?
I don't think Larry Jones is his real name. I think he uses it, you know.
First off, just off the record, I want to congratulate Mr. Jones. He looked,
wake up.
he looked very good there.
You better talk fast though.
Yeah, that's the old Larry Jones I know. What I want to do is we want to rebut some of the testimony. There's many.
Whoa, hang on.
I'm sorry.
I think
We have
there were
public
some folks from
comment.
the public who wanted to speak, and they're allowed to speak as part of the... Before rebuttal, you're last, you're dead last.
Yes, sir.
Do we have any time limit on these people? 3 minutes. Rick, you want to do the? Okay. Okay.
State your name for the record,
Hello,
sir.
my name is Jim Martin, M-A-R-T-I-N, and I have not been sworn in.
Oh, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you will give before this board will be the truth?
I do.
Thank you.
Okay. I live in, 6 months out of the year, I live in Gulf Pines subdivision. We have a house there, 328 Lakeview Beach Drive. We have approximately 90 homes, and this subdivision is directly across from the ingress-egress part of the highway that we're talking about. And I just wanted to stress to you, and I know all these points have been brought up, and it's going to be hard for me to top any of them, but I just wanted to stress to everybody how dangerous it is out on Highway 98 as we have to come out of our subdivision. And to make a left-hand turn is almost impossible. And we can make right-hand turns pretty easily. But there are times when the traffic is backed up from the entrance to the outlet all the way up past the entrance to Sandestin. My wife and I took a trip the other day up to the other entrance of Sandestin, the one by Applebee's. And we wanted to go in to see, how hard it would be to get to this property from another entrance. And of course, it was very, very easy to get there. It's hardly used. And, but we took the trip, and the only thing that stopped us from getting to the property was a lake or a pond. Everybody got the computers up? We just want to go on record as saying we oppose this, and it's strictly from a safety standpoint. And you've seen all the backup and so forth, the pictures and the deaths and so forth. And my grandkids come down. We have 5 grandkids, and a son and a daughter. And the worst thing about this whole setup down here is the traffic. And that's it.
Okay, thank you, sir. Ms. Harris?
Suzanne Harris, president of Edgewater Beach Condominiums. And I think it's a new day in Walton County, and I'm tired of hearing about all the things that went on before and how we did it one way and we did it another way. I think this is a new day in Walton County, and I think all of you showed that it was yesterday at your meeting, and I congratulate all of you. The first thing is that we have a rental business that I run. And I can tell you, when the wreck happened and the person was killed, my guests were 3 hours out to get back to Edgewater because we cannot move the traffic quick enough. By the time the sheriff gets there, the ambulance, fire truck. There's not a fire truck in the world that can make that turn into this property because I went there. I went in my Volvo, and then I went back and got Edgewater's pickup truck. And I tried to make the turn, and I tried to come out. If you come out of the property and go right turn only, and you really wanted to go left, you're either going to try to shoot across into the death lane, or you're going to turn right and U-turn. And the only place you can U-turn is at the Sandestin Outlet Mall, or you can try to get quickly in the left-hand lane, and you can U-turn through the Winn-Dixie parking lot, which is a mess. I went on a rain day, when every tourist in the world is trying to go to the Outlet Mall. And I pulled in that road, turned around in her parking lot to see how long it would take me to get out and turn right. It took me 14 minutes and 32 seconds. I went on a Sunday after church. I whipped in her parking lot, turned around, tried to come out and go right. When I did, it took me 4 minutes and 48 seconds to go right. Then I went on a weekday. I went at 3 p.m. on a Wednesday, and it took me 6 minutes and 5 seconds to come out. I would like for y'all to ask some questions, and I'd like for them to go on the record. Number one, y'all all, 3 out of 4 of you, cared enough about the garbage issue to come and look. I don't know how many of y'all have physically driven down there and pulled in that and come out. But I think before you make a decision, every one of you need to come down there on a busy day and see. Thank goodness you've got a great TDC director in Jim Bagby. I have 176 units at Edgewater. We are full for January, February, full of snowbirds. The snowbirds go everywhere, and they can't drive. Putting more, we've always prayed that we wouldn't be a three-month community, June, July, and August, that we would be able to build the fall season and the spring season. Well, we've not only built the fall season, I was 30% ahead for fall. We were full all of fall. We are, last year, we are 100% full for Labor Day, and I am 80% rented for the whole month of September, and we are full in January and February. We not only built the spring and the fall, but we have built the winter season, and we are the place to come. So what I'd like for y'all to know is I have heard beeps and bells and other things, but what I've heard here today is, and what I heard at the planning meeting when I was on the planning board, I've heard all kinds of numbers, and none match up. Today I've heard 3 different numbers on how many people are going to be in and out. But I'd like for y'all to ask, Number one, how many employee stickers will be able to go in and out that gate? Because even people like Southern Resorts, who manage units at Sandestin, have the sticker on their car that lets them in and out, and so do their housekeepers, because I've talked to them. The second thing I'd like to know is, really, how many parking places are there? Are there 24? Are there 50? Are there 36? How many really are there? What's the square footage of the building? I've heard 4 different square footages, and I don't think any of the 4 I heard are what were on the plans. Then I'd like for y'all to get a guaranteed number. If you pass this, you need them to give you a guaranteed number of how many stickers. Because I can tell you, if I were a Sandestin owner, and my money bought that property, and you told me I couldn't go in and out of that gate, that wouldn't happen. If I built a 3rd pool at Edgewater and told my owners it was only for the board members, but the people that paid for it couldn't get in the pool, it'd be a knockdown, drag out. So these are some of the things y'all really need to think about. And before you pass these, y'all need to come down there when it's raining and traffic is backed up forever trying to get in the Sandestin outlet, and they're trying to get over to the Winn-Dixie and on Miramar Beach Road and pull in that area and see how long it takes you to get out. It's dangerous. It is not right. And this is a new day, and we need to make rules, and we need to do the same thing for everybody that comes before this. And I believe, Kenneth, that's your goal. I believe, Bill Chapman, I think that's your goal, is to physically look and see these things. I know Cindy's been there to look at it, and I don't know whether Sarah has or not, but y'all really need to think before you do this. And we need to think about everything, not just Sandestin, not just these owners. We need to think about the tourists that are getting tired of coming here because they cannot get on the road and go anywhere. Thank you.
Thank you.
Can I offer up something to the board?
Yes.
Okay. I've listened to both sides. I think we have a lot of the information that we really need. It appears to me that that the Reeves property, the frontage, is the key to the remaining parcels in the back. I mean, that's the key. They have to go through there. And evidently they have not worked with the Reeves. And so my suggestion is that I would like to see them go to the Reeves, work with the Reeves, and get a reasonably safe traffic exit there, if at all possible, and come back to us with that, and then I think we could approve it. Otherwise, I'm going to make a motion that we deny the application based on the traffic safety issues.
Ms. Meadows, I don't want to cut anybody short, and I'm certainly a commissioner, but before we make a motion, the way our code is set up, the applicant has a right for rebuttal. So before a motion is made, I would suggest we let Mr. Vorbeck put on what he has. Now, I know the hour's getting late, and I've been here 4 hours too. But,
I mean, I think, though, that we've gotten the gist of the matter, and that they, of course, can put on their rebuttal.
Sure.
But it doesn't really matter how many people are coming and going out of there. I mean, it does, ultimately. But the key to that property's development, now and in the future, is via the frontage parcel, whether anybody likes it or not, in my opinion. They must work with the Reeves, and they must come up with some kind of solution. So I would like to just put that out there for the commission to think about and for everybody to think about, because I think that it's pretty clear to me that the SOA contemplated and wanted a third entrance into Sandestin. And knowing that there was only 11-foot entrance, they bought the property without evidently thinking or looking at the code and the reality of accessing that property. And at a point in the review process, the applicant realized there was a problem with the 7,000 and changed the application to only employers and emergency personnel and made the concession. Unfortunately, this appears to be an ill-fated, not well thought out approach to developing the parcel. And I suggest that the applicant work with Janet Reeves and her husband, as it appears in a legitimate, straightforward way, that appears that their property is the key to any development to the north. With a land use that is coastal center, an entry to the development site is going to be absolutely necessary. And it's got to meet code and it's got to be safe. So I'll stop there, but we can go ahead and have a rebuttal if we want to.
Mr. Warbeck,
Point, can we ask questions?
you,
I think we have more public comment.
just a minute. Mr. Warbeck,
We do have more public comment?
Let's keep them.
See if there's more public.
is there any more public comments? Yes, sir. Either one,
And try not to repeat, things that have been said.
Please.
I'm Bobby Bowick, president of Gulf Pines Associate Inc.
Spell that.
It's Bowick, B-O-W-I-C-K. And everything's been said, but it's just what hadn't been said is let's just use some common sense. We're concerned for our neighborhood on safety on the highway. It is hard to get in and out of our neighborhood. We're a single-family development. Next door, Hidden Dunes is hard. Carib is hard. Some of those people are not here today because somebody put up a balloon. They won't put a traffic light there and said it's all said and done. Sandestin gets what they want. I don't know. But y'all are good, fine people that understand safety and what's important. And our people really need to have the expertise and the time and be safe to get out on the highway. I know Commissioner Chapman, being in law enforcement, understands how important the safety is, and I know all of y'all do. But it's a real traffic hazard. It's a zoo. The middle lane, you got trucks, cars, motor scooters, bicycles, all that. I'm not going to keep being redundant, but I just want to say I wish y'all would just consider knocking this thing down and let's move on to something really important. Thank you.
thank you. Yes, sir. Mr. Riley?
Don Riley. I live at Grand Dunes, give or take a few yards, about a quarter mile from the street in question today. I've personally been pretty close to getting rear-ended pretty hard there at that very turn in question, coming towards the Outlet Mall from here. Parenthetically, about 85 to 90% of my driving is done to come here to listen to, and on occasion to irritate y'all. I do my darndest to walk when I'm here because the traffic is so miserable. Suzanne gave you some times for her about 3 or 4 years ago, summertime. My wife went down there to Footprints, and she was complaining bitterly about the 45 minutes that were required to drive that quarter mile. It took her 30 or 35 minutes, I forget, to turn right out of Footprints. The traffic hasn't gotten any better since. The other point, and on the June 21 wreck, I was coming from Destin. I noted when I went towards Destin, boy, the going west lane sure is empty. Must be a wreck down towards Sandestin. And coming back, it took me 2 hours to come from Hancock Bank in this side of Destin. The traffic is bad, and when there's wrecks, it's beyond bad, and the wrecks are quite frequent. The other thing is something that I've addressed before in a different milieu context, and that is equal treatment under the law. I won't belabor what Alan has had to say other than to echo that I think that the two most important things that y'all do are public health and safety and seeing to it that all citizens get treated equally under the law and that you fairly and uniformly enforce all of the laws and the codes. Mr. Vorback has not had an opportunity to present a rebuttal, absent having heard a rebuttal of the assertions of Alan, which I think are unrebuttable, or Ms. Cruz with regard to Crazy Carl, was it? having heard no rebuttal to that, I would urge that if that indeed is the prior means by which y'all have made decisions, you as a continuing board, even prior to the existence of this new and I think better board, I would urge that you follow the precedent so we'll all know what to expect when we get here. Thank you very much.
Thank you. Anyone else? Mr. Forbat?
Yeah. Mr. Chairman, board members, appreciate the opportunity to rebut. There's a lot to rebut, many issues, and so I'd like to start off with Dean and some of the issues, and then we're going to have a couple other witnesses to rebut all the complaints.
Thank you. Again, Commissioners, Dean Burgess with Emerald Coast Associates, 179 County Road 393. First of all, let me just try to clarify and dispel some of the, much of the testimony that was heard tonight references an 11.01 foot driveway. That is if the driveway were to remain in its current state. Our proposal is to put in a 20-foot wide 2-lane access. We've never proposed to keep the access, the 11-foot or 12-foot wide access to the property. All of that is prefaced on the point of if we were to keep it in its current form, which we have never proposed to do. First set of comments I'd like to reply to.
I guess, and on that comment too, I guess, that assumes that you have the right to increase it and expand it. I guess we're all assuming that. Okay.
Right.
Okay.
We nor do I believe staff sees this as a viable access without improving it.
Do you see it as a viable access at 20 feet?
I do.
With safety, you see any safety issues there?
No, as a matter of fact, our own code limits the width of access on Highway 38 at 22 feet.
No, I mean, do you see any safety issues there with having a non-DOT permitted access there?
Well, it would be a DOT permitted access. We would apply to DOT and apply to expand the access to the west. That expansion would occur entirely within DOT's right-of-way, not anywhere outside of the DOT right-of-way. Then we would tie our road in line with that access. So it would be a full 20-foot width.
Right. And again, that is assuming that, you would have the ability to do that.
Yes, ma'am.
Okay.
In response to Ms. Cruz's comments, the first item that she addressed is the power pole. I wanted to clarify that power pole, as shown on our survey, is not within the easement. It is right on the edge of the easement. I think the impression that was given to the board is that it's sitting right in the middle of our easement. It's not. It's to the edge of the easement and not within it.
Which easement? The one back from the 70s when Gulf Power got it, or the one you purport to be the easement that y'all have?
The 20-foot easement that's included with our deed. That is a part of our deed.
And it includes the 10-footer from the power company?
It includes 10 feet of that. The power line easement is within that 20-foot easement. Yes, sir.
Thank you.
It's not uncommon to have access and utility easements encumbering the same space.
So how far would your driving lane be from the Gulf Power pole there?
From the pole, I would have to produce a survey on that. It would be very close. The 6 feet referenced, I believe, is in, they like to maintain a 6-foot distance from the travel lane of the DOT road, which would be Highway 98, not the driveway in question. So that 6-foot distance would be accommodated from DOT's roadway.
Will Gulf Power allow you to build a road that close to a power pole?
I would have to have that conversation with Gulf Power.
I know we got a road in the north end of the county where they won't allow us to go right away. You can do nothing in their easement. I mean, we can't even we wanted to pave the road and they wouldn't allow us to do it. It wouldn't be Gulf Power's. It was Shelco. But I'm sure all the power companies have the same issues about building close to a big utility line as big as that is. That's a big utility line that's going through there. A lot of
And if it were, if we were required to move that pole, if it were too close to the pole to meet their standards, we'd be obligated to do so.
I'm going to interrupt this testimony. Could I have a break of 3 minutes?
Yes, sir.
Is that, if that's okay with you, 3 minutes?
Yes, 3 minutes. Yes, sir.
Yeah, we may leave.
It's getting close to supper time.
You ready to come back to order? Okay, Mr. Vorbeck?
Mr. Chairman, I apologize for interrupting, extending this meeting. What I would suggest and ask you all to do is that I heard what the commissioner said, and she would like us an opportunity to work with the Reeves. And we'll exercise that opportunity. What I'd like to do is extend this to the next Board of County Commissioners meeting. This meeting, as it stands right now, you know, we're in the middle of rebuttal, and Dean's in. I cut Dean off, so you're going to have to hear more from Dean. But if we could cut it off right now, extend it to work with the Reeves, try to work something out. No guarantees, and see if we can work with them to, as Ms. Meadows stated, and come back and tell you whether we're successful or not. But it takes two to tango, and so we'd like that opportunity. And so I'm suggesting that we do that, extend this, continue this to the next board meeting, and then we bring back our rebuttal witnesses and go forth. So is there any questions of me, what my requests are?
Well, I'm
The Reeves object to this.
well, I'm sitting there looking at Mrs. Reeve.
And I would like some questions answered. Can I?
Yeah, all you gonna do is rebuttal it the next, that's all you, that's it. Just pick that right where you're at.
But I would also like some questions answered if possible, and Mark, tell me if I'm going in the wrong direction.
You can ask any question you.
That I want. The power pole is a concern to me.
Oh, we'll get Dean up here.
No, I don't want to know. I want this, I want something from Gulf Power in writing, not he said, she said, and they said, that they're willing to move this pole, and where are they going to move it to? Because I don't see how it could possibly be moved. And, you know, I know that we have to make our decision based on the law and not common sense, and that's unfortunate. But I have some concerns there with the turning and that sort of thing. So I want to know if that power pole has to be moved, where's it going to be moved, and what is that? And also, is it my understanding that they have no other access to this property? None? Zero? Except this easement?
No,
until they build a bridge?
Until they build a bridge.
They can't, like, come around that way through Sandusky? And why not?
Not available.
And in other words,
not another.
Okay, I mean, that's, I mean, I just.
They have to go across the good side.
You have to, okay, you'd have to cross water on both sides, I mean, all the way, it's surrounded by water on all sides, is,
Who's on the west side of this?
yeah, who's on the,
To the west is the RV park, there's a mobile home park.
Destiny's.
Show.
Yeah, Destiny.
yeah, that's what I want, yeah,
Yeah, actually.
Well,
yeah,
Here's
It-
the RV park.
uh-huh,
Here's the property in discussion.
uh-huh,
It's actually just a rectangular piece,
Uh-huh.
and this is the easement. And this is the Reeves property.
can't come through the RV park.
Can't go through the RV park, they're gated off.
Gated.
We have
Okay, I mean, I'm,
seek access to
it looks to me like this SOA bought this piece of property without doing their due diligence. The key is the Reeves. If the Reeves don't want them to come through it, then I think they're out of luck. That's my personal opinion. And based on what I know about property, they're out of luck. I mean, this is something that should have been resolved before they purchased the property, I think. Or with the Reeves, because now they've got something that you're being sued on the back end and you can't go out the front end.
Well, and that's something that we
yeah.
will have to work through as far as the
Right.
back end. And if the Reeves bring an
But-
action against us, then that's something they'll have to do too.
Right.
I don't want to argue that point, but we will try to work with the Reeves, but it may not be possible to come to a proper conclusion.
That's right, and it may not be possible. And what I'm saying is that based on traffic safety issues, there's no way that I can't approve, I couldn't approve it. So, if you don't get
Well, I hope
that.
you reserve
work it out.
judgment until we
Yeah.
put on a rebuttal.
Well,
Pardon?
Okay.
She made her decision before you ever got.
I take exception to that. Who said that?
Yeah.
You want to stand up?
Sir?
Now, how do you know
Sir?
that, Mr. Abraham?
I heard what you read.
Hold on, Miss Meadows. Sir? You're out of order. And state your name. Yes.
Abraham, like Lincoln.
Yeah, okay.
Right.
Go ahead, Miss Meadows, you go ahead now.
Okay. No, I came in the meeting with an open mind, but I've heard enough. I mean, I don't need to hear a rebuttal. I've heard enough based on what I've heard.
With all due respect.
I still don't know how many people y'all are going to proposing to bring in and out.
Well, we'll be, I mean, I thought this was something the board wanted us, Ms. Meadows, you wanted us to do. I mean, we're prepared now to bring our rebuttal and answer all your questions and be here until we get that done. But that's your call. I was just reading between the lines.
I don't think it's going to help the traffic safety issue. I mean, I think that's the main issue with me. It's the traffic safety issue.
Then I respectfully ask that you wait till all our testimony's in.
Okay. I would like, because I want the SOA to have their building but I want safety as well. So I would like to give opportunity for them to try to at least talk and sit down and work with the Reeves one more time, if you will do that. That will give me a comfort level. Yeah.
Okay.
Well, there's two ways to proceed here, two possible ways. One, there would be a motion to continue the matter until the next county commission meeting. Or two, if that motion does not carry the day, and the purpose of the continuance would be to allow, as Ms. Meadows suggested, the applicant and the objectors to meet to try to work out their issues regarding the access. Or two, simply let them finish the rebuttal, have a vote today, and move on. Those are your two options, right?
And we're going to be a while. I mean, we've got a lot to rebut, and a lot of things are on the record.
In that case, Mr. Chairman,
and listen, we've been here 4 hours. You can always choose, regardless of whether they talk to each other, you can always choose to continue it.
Because I don't think we can do it on the next county commission day. I believe we're already booked with planning. How many planning issues do we have on September the 10th? 8 or 9.
And we have a pre-meeting presentation.
And we have a pre-meeting, so I think we should try to do
Special meeting?
a special meeting. And that's because we don't need to be sitting here, because y'all lose, after about 8 hours, it's like sitting and listening to a Baptist preacher. After about 8 hours, you've lost me, So I'd like to have a special meeting,
Is that a motion?
Wait just a minute, let's get a day. Hold on, let's get it, hold on. You make that motion?
I'm just asking Mr. Davis at this point,
Yeah, I'll make a motion.
If we need a motion, then.
That we continue? Is that
Yeah,
what you
let's get the date.
Okay.
If we have it, yeah.
Yeah,
You can
we
make the motion.
continue the
Oh, so-
hearing.
okay.
You want, 2 weeks from today will be September the 11th?
I'm good.
September.
Is that a Tuesday, Wednesday?
Wednesday.
Yeah,
What time?
Yeah.
What
I'm
time?
good.
What time you want?
what time?
I'm saying 9.
9 o'clock, let's start in the morning.
Here?
The 11th?
September 11th at 9
Well,
o'clock?
we've got a meeting the 10th, the night of the 10th. So
Right.
We'll
It'd
be here
pretty
till,
late.
we
Okay,
could
so
be
you
here till
wanna
midnight.
do it in the
so
afternoon then?
That's my preference.
1 p.m.?
Yeah,
Okay.
let's do it at 1 p.m. Yeah.
Okay, we'll need a motion to that effect, and we'll
Motion.
hear Ms. Cruz' objection. Okay.
That's your motion, Mr. Mayor?
Yes, that it be continued to September 11th at 1 o'clock here? Yes.
Second.
Second. Do you want to make us a brief comment?
Will be very brief. I do want to object on behalf of the Reeves to continuing, but I also want to point out something that maybe people have forgotten.
Well, if you,
Ma'am, ma'am.
Well, if the issue is security, the Reeves plan shows
Yep.
that
Yeah, we don't need, yeah, but you don't need to go there. We don't need that right now, Mark.
Yeah, if you want to argue the motion for continuance, that's what I would argue at this
Yeah.
point.
We
Argue the
We
motion for
don't need to be,
continuance.
okay,
I'm assuming you object to the motion for continuance?
We do.
Okay.
okay.
Because we were
So
here
noted.
to resolve the
Okay.
issue, it's been delayed already once.
We got a motion and a second.
Mm-hmm.
All those in favor?
Aye.
Opposed? Motion carries. That it?
Mr. Davis, you were going to go on record as with respect to the conversations that had transpired.
Mr. Abrams.
Yeah, Mr. Jones was asked to ask them if they would be willing to talk to your folks. And I think that was the extent of the question, and he came back in and said they were. Yeah, they just
Mr.
asked.
Dice,
Chief wanted to know
do you
what
want
was
us to
asked.
leave our books for you to, so y'all don't